go from there, okay? Does that sound?
I'm fine with it, Judge.
We're on the record then, in case the state of Arizona versus, we have been on the record, in case the state of Arizona versus Christopher Van Ruff, 2021-306-3564, the parties have already announced it's the time set for a non-jury trial. In this matter, it's 1 count criminal trespass, data violation 10/6/2021. Are there any, is the rule of exclusion, I don't know how many witnesses or what witnesses we have, and we have several people in the courtroom.
Judge, the only other witness for the state that's present is Officer Wilcox. She's not in the courtroom now.
All right, is the rule being invoked by anybody, I guess?
The state would invoke the rule, Judge. I don't think it's necessary, but we
The rule of exclusion is invoked. Are there any witnesses in the courtroom that you have?
There are not, Your Honor. Everybody in the courtroom on our side is a spectator.
All right, so given that, I guess we don't have anybody in the courtroom that I need to advise, but should there be a witness that comes in, please let me know. Opening state.
State will waive, Your Honor.
Defense, do you have an opening?
We'll waive as well, Judge.
Mr. Hawkins, why don't you go ahead and call your first witness?
Thank you, Your Honor. The state calls Officer Ader.
Sir, if you could come around to the witness stand. If you can raise your right hand for me. Do you swear from the testimony that you're about to provide will be the truth and nothing but the truth?
I do.
Go ahead and grab a seat, officer. Whenever you're ready, Mr. Hawkins.
Thank you, Your Honor. Officer, would you please state your name for the record?
Officer M. Adair, ID 18901.
Can you spell your last name for me, sir?
Adair.
Thank you.
Officer, where do you work?
I work for the Mesa Police Department.
And how long have you worked there?
I've worked for the Mesa Police Department for approximately 11 years.
Back on July 13th, 2021, what was your assignment with the Mesa Police Department?
I was working patrol at the graveyard at the Fiesta station.
And as a patrol officer, what do you do?
Routinely take calls for service and also conduct on-view activity as in traffic stops and patrolling areas to make sure that everything is okay.
On July 13th, 2021, were you called to 1410 South Country Club?
Yes, sir.
And about what time of day or night were you summoned there?
My brother's my report.
Would that refresh your recollection?
Yes, sir.
Your Honor, may the officer refer to his report?
Yes, he may. You know what, counsel, let me just advise both of you, I think I called the wrong case. We're actually in case 2021-043799, so I apologize.
It's approximately midnight.
Why were you summoned there?
I was summoned to assist another officer who was on a traffic stop, as she had advised that she had First Amendment auditors showing up who were known to cause problems for officers.
When you showed up to that, let me ask you this, is that address in the city of Mesa?
Yes, it is.
When you showed up to that location, what did you observe?
At that point, I observed multiple subjects with cameras standing on the property and videotaping officers' traffic stop, and also appeared to be kind of encroaching on stuff.
What's located at that location?
At that time, it was, I believe it was called American Inn and Suites. It's a hotel.
And what did you do when you first arrived?
When I first arrived, I notified other officers who were on the scene that the subjects needed to be moved off property because it was no trespassing property.
What does that mean, a no trespassing property?
It means that they, basically, if you're not a guest at the hotel, they don't allow you to own the property. They have system, I believe they were on the no trespassing enforcement at that time, which is a program the city of Mesa has where a company can request that officers can actually act in behalf of the owner to trespass people from the property to go to the wrong way.
And how does that program work? Does the company have to convey to Mesa PD, hey, we want to be on in the no trespassing program, or how do they give you that authority?
It's a program where there's paperwork and such involved that they file with us saying that, you know, they give us the permission. But the property also, from previous calls for service and such, I know don't allow people, trespass people normally from the property.
So is this property part of your normal control area?
Yes, it was at the time.
And it sounds like you've worked with this property in the past?
Multiple times.
So when you showed up, you mentioned there were multiple people with cameras on the property, and then you conveyed something to the other officers?
I just advised the other officers that the soldiers needed to move off of the property because it was no trespassing property.
And did that occur?
Ultimately, yes, I believe the sergeant actually advised officers to put up tape to cordon off the area. Subjects didn't move off property right at first. They actually went and spoke to the security guard and clerk that were working over the property.
At some point, did you come into contact with an individual who became known to you as Christopher Rupp?
I did.
Do you see him here in the courtroom? If so, would you just point him out and describe what he's wearing for the record?
Yes, sir. He's wearing a plaid button-up shirt with a gray long sleeve underneath and blue jeans.
Your Honor, would the record reflect that the officer has identified the defendant?
The record will so reflect.
After you arrived on scene, when did you first come into contact with the defendant?
I came in contact with the defendant not till later as I was removing tape from the officers had put up.
Sorry, just for my clarification, you said you didn't come into contact with him until you were removing the tape?
Yes.
And you personally were removing the tape?
Yes.
Were you wearing an Axon body camera that night?
Yes, I was.
Now I'm going to play a little bit of this for you just so that we can clarify whether this is your Axon body camera. Now with Axon cameras, generally when you play them, the first 30 seconds doesn't have any sound, right?
Correct.
Alright, let's go take the time. I'm on, so. Yeah.
So, and I'm sorry, can you tell at this point whether this is your Axon?
Yes, sir.
Okay, and we can see in the video, and I'm going to let it run here. We can see the tape that you referenced across the property. Do you see? Have we seen the defendant at all in this video yet?
Yes, sir. He's going to be the one on the right with the long sleeve shirt with the camera.
Okay, and what color is the shirt?
Looks like a gray or a white, it's light color.
I'm going to go ahead and skip ahead here.
Mr. Hawkins, is this, sir, is that a number?
There is, Judge. This will be marked as exhibit number 1. can't see it. I'm going to try to highlight this, but, well, I'll cover it later.
You think this is gonna help? You guys trying to get that lost man? Approach them. Lots of games. You know what the game is, dude.
You need to step back.
Okay, now at this point, did you ask him to step back?
Yes, I did.
Okay, why did you do that?
Alright, so when I turned around, he was actually standing partially on the property. And so I advised him he needed to step back so he could be off the property.
Is there a clear divider for the property there?
The property is from the sidewalk, which is concrete. The motel's property begins where the asphalt begins right at the edge of the sidewalk.
Now, at the time that you say this and you ask him to step back, has he already been moved off the property by other police officers?
Yes, sir.
At that point, you technically didn't have to ask him to get back off the property, did you?
No, sir.
So why did you?
He wasn't very far on the property. I was just giving him an extra warning so that way he knew that he needed to step back.
You need to step back.
Okay, so when you asked him to step back and you gave him that additional warning, what was his response?
He stepped further onto the property, kind of towards me a little bit, and told me to shut up, motherfucker.
Okay, Sergeant, we're at 15, this one right here.
Don't
Put your camera down. You're under arrest for trespassing.
Dude, I had no
Put your camera
You
down.
guys see this right here?
You're right here on the property that you've already been asked to get off their
This is
property.
like an easement. Oh, are you serious?
Put your camera down.
You guys see this right here?
Okay, so at this point, do you place him under arrest?
Yes, I did.
So I got these pushed.
Yeah, it's a chest now. Yeah, it's got. You guys got to put me on official trespass list and release me. I have to violate official trespassing before you can arrest me. You know that, right? I was not on the list. Hey, Sarge, I've never been officially trespassed.
Okay, spread your feet for me.
Sarge, I've never been officially trespassed. You got to put me on a list and release me. Once I did the property management on saying you want to lobby on property, and I left.
I'm just going to play that last part one more time.
Your Honor, I'm going to object as the sergeant's statements are hearsay. Whoever was speaking to Mr. Ruff, his statements are hearsay. Mr. Ruff's statements are not, but I believe the state's trying to play the clip of what an officer was telling him, which would be hearsay.
Judge, hearsay is an out-of-court statement being admitted for the truth of the matter. There's nothing being admitted for the truth of the matter here. The sergeant asks, were you told by management to get off the property? Nothing's being asserted there. There's nothing being asserted for the truth of the matter. It's a statement that's recorded live. This is the best evidence of that conversation. And defendant's response was, yeah, and I got off. Or something of that nature. I'll play it again. But it's not hearsay. There's nothing being asserted for the truth of the matter.
Right, but no, I understand that. Overrule the objection. Go ahead.
Sarge, I've never been officially trespassed. You got to put me on a list and release me. Once I did the property management on saying you want to lobby on property, and I left. I left.
And Judge, I'm going to renew my objection. I didn't hear him ask a question. I heard a statement, didn't management tell you can't be on the property? That's a statement by him trying to express that he had knowledge he wasn't supposed to be on. That's the officer making a statement. I believe it's hearsay. I move to strike.
It's also a statement from your client. It's an admission or a statement made by the defendant in response to a question. The defendant's statements are admissible. It's overruled. Go ahead.
Did you subsequently issue a citation to the defendant?
He was put in jail and a citation was issued for court purposes.
Judge, the state would move to admit Exhibit 1 into evidence at this time.
No objection.
Stage one is admitted.
Down and off their property.
Okay, officer, I'm now going to play a second video for you. Do you recognize this video?
I believe this is actually Mr. Russell video.
Are you in this video?
Did you get a call,
I'm
stupid?
standing on the passenger side of the video.
That's you right there?
Yes, sir.
So,
Yes, sir, I'm sorry.
I mean, I know you're playing a video. Is there,
Yeah.
Yeah, and I was going to get there, Judge.
is there a stipulation?
There's not, Your Honor, and I'm going to ask for foundation. I don't believe there's foundation to play this video.
And I was going to get there, Judge.
Okay.
Officer, is this video an accurate representation of the events from that night?
From what I've seen in person.
Okay. I'm going to play you the same video that we played on your axon, the interaction between you and Mr. Rupp. And I'm going to ask you again if that was an accurate representation of the events from that night.
see what they got for us here.
Okay, is that you in the video?
Yes, sir.
No number markers.
Do you think this is going to help when you guys try and get them laws passed? Approach them.
Does this appear to be a recording of the same interaction that we played from your axon?
Yes, sir.
Does it appear to be an accurate representation of the events of that night?
Yes, sir.
And cause chaos. We
So I'm just going to back up for a second.
see what they got for us here.
No number markers.
Do you think this is going to help when you guys try and get them laws passed? Approach them and cause chaos. We know what the game is, dude. Did you get all of us? Did you get all of us on body? Shut up, motherfucker. Yeah, get me on body cam saying dumb shit so you can get a law passed. Ed Westing ain't smart. We know what the game is. Bye-bye, sucker. Don't touch me. What are you doing? What are you doing? Do that.
You know, the state would move to admit Exhibit 2 into evidence.
Judge, I don't have an objection to the admission and publishing of the portion that was just viewed, I would argue that anything outside of that purview is inadmissible, as there's no foundation. I agree there's foundation for the portion where, on this video, where Officer Dare is directly engaging with him. So as long as this is the portion that's being published to the court, I don't object to the admission of this portion of the video. Anything beyond that, I would object to.
Judge, I don't intend to, at least at this point, intend to play any more of the video, but frankly, Officer Adair can lay foundation for any video that he was present for, that he can testify as an accurate representation of the events of that night. Now, granted, he wasn't on scene the entire time. Defendant was, I believe, was on scene prior to Officer Adair, so I'm not trying to go into necessarily video at this point. That Officer Adair wasn't on scene and couldn't verify that it was an accurate representation. So, I mean, in theory, I don't have an issue with defense counsel's position. I'm really, guys, saying that I wouldn't want to preclude it if we do need to delve into something, and Officer Adair can lay the foundation for that. The state feels like it should still be able to go into that.
And Your Honor, well, I'll let the court rule on that issue, and then I have another issue I'd like to raise.
So obviously, I think the video, just like photographs, is relevant to the foundation. I'm not talking so much about statements that were made, but area where the defendant was standing, where the officers were standing. The court finds that to be relevant, and the court finds that the officer was there. And obviously, we have a video recording. If you can lay the foundation, then as to that, it comes into evidence. I don't, and as far as the defendant's statements, those come into evidence. So I don't know. Understanding I haven't looked at anything, I haven't seen anything, so I don't know what more is going to be played. So I don't want to just give a blanket ruling without knowing what other portions are going to be played. And obviously, I view this. I don't know if Mr. Hawkins is going to go into something else.
I don't intend to at this point, Judge.
And Your Honor, so, and again, this is sort of an issue of practice in a bench trial versus a jury trial. If this video was going back to a jury, I would want it redacted just to the relevant portions. I trust the court understands the points that I'm making regarding foundation. Anything in this video where Officer Dare is directly involved, I think there is foundation. I'm okay with those portions being played. It's a 25-minute video. I would take issue if the whole 25 minutes was going back to a jury. I trust the court to understand that distinction. Similarly, I do object to the way this is being played, specifically the comments that are written on the right. Those are not part of the actual video being played. They're not relevant. I'm going to ask the court to ignore those.
So I haven't, just to let you know, I intentionally,
as the trier of fact,
have not looked at any of that. I see that they're on there, but I had intentionally not looked. I can't tell you a name or word,
okay,
because obviously I know that there must be some sort of commentary, so I've purposely not done that.
And I trust the court on that. And again, it'd be a bigger issue if this was a jury trial. As the judge is the trier of fact, I'm just going to ask that you continue to do what you're doing and disregard the comments to the right. With those provisions in place, I don't object to the admission of the video for those limited purposes that I laid out.
Go ahead. Continue, Mr. Hawkins.
At this point, the state doesn't have any further questions for Officer.
So this states two.
This is states two, Judge. Judge, actually, let me just add. I will ask a couple more questions. Sorry. Judge, this is. Officer Adair, did you clearly observe the defendant go onto the property of the motel?
Yes, sir.
After you observed him clearly go onto the property, did you ask him to step back?
Yes, sir.
You asked him to step back. Did he then go back onto the property? Or, well, actually, let me ask you this. Did he ever, when you asked him to step back a little bit, did he step back and go off of the property?
No, sir.
I have nothing further to.
Cross-examination.
Thank you, Judge. Officer Adair, have you had previous encounters with Mr. Ruff in the past?
I'm not positive I've had encounters with Mr. Ruff before this point or not.
So it's your testimony today that you have not had previous encounters with Mr. Ruff at the scenes of arrests or at any point in your capacity as a law enforcement officer?
Not that I recall.
Hang on just a minute. Mr. Hawkins, I'm seeing people come in, I don't know who
Yeah,
is or who is not your witness. So.
Judge, let me just step out and say, I believe this may be Mr. B.
Okay.
That is Mr. B.
Proceed, Captain.
Okay, thank you. Are you familiar with who Mr. Ruff is, aside from this encounter?
Yes.
How are you familiar with who Mr. Ruff is?
Because of speak about who directly is and as him being one of the First Amendment auditors that's normally on scenes.
What is a First Amendment auditor?
They are subjects who basically follow around officers, come to traffic stops and such, and film and record, and a lot of times harass and yell at speeding officers.
And does your department, the City of Mesa Police Department, do you guys have any sort of policies or procedures in place for when you encounter people like Mr. Ruff?
I guess I don't really understand.
Do you guys have an office policy on how you're supposed to respond when people like Mr. Ruff, the First Amendment auditors, are present at the scene?
State of objective relevance, Judge.
Goes to bias and motive.
Basically, if they are not bothering or doing anything with us or interfering with anything, then we let them film. It's their right to film. If they are interfering with our scene or what we're doing, then normal practice for most officers is we tell them to back up and to move.
And so, in this particular case, was the issue that he was interfering with your scene? What was the issue with Mr. Ruff in this particular case?
We got called ultimately to begin with to assist with the traffic stop because they were encroaching. They were taking the officers, her attention away from what she was doing because of the fact they were encroaching, they were yelling, they were screaming, they were doing different things.
I heard you say that. Was anybody else arrested in this case?
No, sir.
Only Mr. Ruff.
Yes, sir.
You would agree with me that it was dark outside when this took place?
Dark with light.
So evening time, nighttime.
Nighttime.
Okay. At some point, did you speak with Mr. Daly, I believe Jason Daly, security guard at the hotel?
Yes, I did.
And without getting into what specifically said, was one of the things that you asked him specifying the property lines?
Judge, and I'm sorry to interrupt, and it doesn't have to do with counsel, it's my question. I would ask the court to reiterate for everybody in the courtroom that they're not to video record this trial, these proceedings, the witnesses, specifically the gentleman right behind me. The court would just advise everyone.
Let me be clear. This proceeding has already commenced. If you wanted to record, you needed to let me know in advance pursuant to the rule. If you have not contacted me and given me that notice, you are to shut off all devices. Nobody else has made a request to allow this court to allow them to record. That is what the rule states. So because that didn't happen, if you were in this courtroom and if you are recording, you need to shut off your devices. There was only one request made, and that was by Mr. Ruff, and that was granted. Everybody else who is in here, you may not record, you may not take pictures, you may not take any video recording. I want to make sure that my ruling is clear for everybody else. So, sir, if you have your device on, you need to shut it off. You understand me, sir?
Understood, sure.
Did you shut it off?
You need to request within 7 days, right?
Did you, sir, is your device on?
After, prior to
Okay,
7
sir,
days.
I'm not.
I said understood, yes, Your Honor, that's what I said.
Is your device off?
Yes.
Okay, very
I'm
good.
not recording, I'm not doing any kind of video or any kind of.
I appreciate that.
Checking it off.
I appreciate that. Thank you, sir.
I don't know why I wouldn't even be a question, but okay.
Please comply with Are we good? Can we proceed? Yes. Thank you. No, that's cool. Thank you, Judge. Lost my spot, officer. I think I asked you. You spoke with Mr. Daly, who was a security guard at the hotel where you were present, correct?
Yes, sir.
And was part of the purpose of speaking to him to clarify the property line, to determine where exactly the property line begins and ends.
To clarify, so that way it was on my recording.
Okay. So you would agree with me, though, that on this particular property, the property line is not defined by any sort of a wall or a fence or anything like that?
That is not defined by a wall or fence?
Correct. There's no wall or, in the area that we're talking about, there's no wall or fence that was built to keep somebody from crossing, correct?
Yes, sir.
In fact, the line that we're talking about here is where a sidewalk turns to asphalt. Is that correct?
Yes, sir.
You would agree with me that a sidewalk could be a high traffic area where people are walking, correct?
Yes, sir.
And you agree that anybody walking on that sidewalk has every right to be there and to do that?
Yes, sir.
Okay. Do you think it would be uncommon for somebody walking on that sidewalk to set a foot or two onto the asphalt ground that is directly next to it?
Most people that I see walking on sidewalks is large enough that they are able to usually stay on the sidewalk.
Okay. Now, would you have an issue with somebody if somebody was walking down the sidewalk and ventured over into an area that was the asphalt? Would you say, "Excuse me, you're trespassing"? If they were walking.
If they were just walking, no.
And again, there's no debate from you. What we're talking about here is really just a matter of a couple of feet that you allege Mr. Ruff stepped onto the asphalt, correct?
Yes, sir.
He wasn't inside the hotel, correct?
No, sir.
He wasn't up near the front desk where you spoke to Mr. Daly, correct?
No, sir.
He wasn't on the big grass area in the front that's pretty clearly defined, correct?
No, sir.
He was on a piece of asphalt. It was a foot or two off of a public sidewalk. Do we agree about that?
At least a foot or two. Yes, sir.
I believe you testified as well that you put up tape in that area. Why did you do that?
That was direction of the sergeant. I did not put up tape. Other officers put up tape by direction of the sergeant.
Generally speaking, what is the purpose of putting up tape? What are you trying to do as an officer when putting up tape?
It's to keep people back from the area that we're working.
Okay. Is it to create a barrier between people and you? To create a boundary? Is that fair to say?
Yes, sir.
Okay. Effectively a property line on a crime scene. Fair?
Yeah, you can say that.
Just to be clear, at no point did Mr. Ruff cross the line that you guys put up, correct?
No, sir.
Can I ask then why the property line you put up would not have been on the property line of the hotel if that is the area that you're trying to protect?
I didn't put up the property line, or I didn't put up the tape.
Okay. But you do acknowledge at no point did he cross the tape that was put up by Mesa PD.
Not that I know.
It was there to protect the scene.
Yes, sir.
Do you know if Mr. Ruff was on any sort of a trespass list before you engaged with him at this scene on your body cam?
No, sir.
You're not aware, or you know that he was not?
Not that I am aware.
Do you recall at some point during your conversation with Mr. Daly, a fellow officer inquiring about if they wanted him put on the list?
No, I do not.
How do I instruct this? Sorry. Come on, this is your pen.
Oh, we have hours like this. Just go. Oh, you can see that.
All right, good. Thank you. Officer, I'm going to direct your attention to your body cam footage. I believe this was already admitted as exhibit number 1. Can you see that okay?
Yes, sir.
Okay.
Counsel, can you be more specific as to when you said on the trespass list? You mean for that property or in general?
Correct, for on the property. So
Thank you.
at some point, you and a fellow officer went to go speak to Mr. Daly, correct?
I believe somebody else would be.
Yeah. At any point during that conversation, do you remember either yourself or another officer asking if they wanted Mr. Ruff to be put on the property trespass list at this time?
No, I don't.
You don't recall. Is that like queued up on there? I'm gonna get back to that in a minute. For now, I just want you to take a look at this big video. Now, this still frame is actually fine. Is your position, Officer Adair, that as we're looking at the screen right now, Mr. Ruff is or is not trespassing?
I believe he is not trespassing.
Okay. And it's harder to see up there than on the computer. Are you able to distinguish a line between where the property begins and ends looking at the video? It's a little grainy up on the screen. Are you able to distinguish?
Vaguely, I want to say he's right about the line.
Would it be fair to say, for clarity's sake, that the line probably begins somewhere about where the red curve would start? Does that seem about right from what we're looking at?
Somewhere right about there, yes, sir.
Okay. So again, we're in agreement that as we stand here right now, Mr. Ruff is not trespassing, correct?
I don't believe so.
Is that it's much clearer on the computer. So Judge, I'm confident if you needed to look at it, it would be clearer. Are you using your, is this popping up on your computer, Judge, or no? For the court?
Maybe, Sean, if you make it not full screen, it might make it better quality. Push escape.
Might be able to dim lights or something like that.
Maybe hit the lights a little.
No. I don't know how to do that. Okay, but look, if we're in agreement that the edge of that red curve is approximately where the asphalt will begin, it's clear to you from this video that Mr. Ruff is not on that side of the property, correct?
Yeah, I don't believe at that time he was.
And you would agree with me as well that the tape that was put up, admittedly not by you, is within the asphalt line that begins at least a couple of feet, correct?
You mean with on their property further?
Correct.
Yes.
There's about 2 feet of what we would say is hotel property that goes beyond the lines that Mesa PD put up. Fair? Okay.
You think this is going to help if you have time to get lost, man? Approach them. You know what the game is, dude. Yes.
So it's your position that he is now trespassing.
Yes, sir.
Step back.
At any time in the video, did you hear yourself tell him, or are we mistaken, did you at any time tell him that he was trespassing?
No, I told him to step back.
Did you ever tell him where the property line officially begins and ends?
No, sir.
Did you ever tell him that the police tape put up by Mesa PD is not in fact the property line, that it is the asphalt that you believe he's now stepped onto?
No.
Why didn't you let him know, hey man, you just took one step onto private property, take a step back?
Because I didn't feel I needed to. It's clearly separated from the sidewalk, and so I advised him to step back.
And you maintain that that is still clear even though you put up police tape within that boundary?
Yes, sir.
Okay, and then this is when the arrest takes place again, correct?
Yes, sir.
And this arrest is entirely for criminal trespass, not for anything else?
Yes, sir.
Can you pull up the video? So I'm going to play a video for you right now.
So, Counsel, what you just played, that was that.
That had already been admitted
Right,
as
so that's
Exhibit 1.
stays-
This I'm going to lay the foundation.
To us, anyways. So.
So I'm gonna talk to you a little bit. Do you have any? Do you believe that this is still body cam footage from the night in question? What we're looking at right now?
Yes, sir.
Okay. Do you recall going up and having a conversation with Mr. Daly, who was security for the hotel?
Yes, sir.
I'm gonna play a portion of this just to confirm that this is the conversation we're talking about.
What's that?
Come over here.
Sorry, Judge, at this point, I'm going to object to foundation. I don't know. Is this Officer Ayer's body cam or is it someone else's?
Is this your body cam?
Yes, sir. It
Okay.
appears to be.
That's all I needed. Thank you.
No, yeah. They don't listen to us anyways. So.
Yeah, I already told them, you know, you guys can't be on the property.
Alright.
What did they tell you when they told you to get off the car? They go over trying to record, can come over here, have permission to come over here and record. I said, no, yeah,
You heard him say that they asked for permission, correct?
Yes, sir.
And he said no.
Yes, sir.
And when you engaged with Mr. Ruffle, was he standing where this took place, or was he standing where this gentleman is pointing?
He was standing on the sidewalk off to the side. Well,
the property.
I guess let me ask you rephrase your question. I don't. I guess when I engaged with him, he was partially on the property. But when I first walked up and started taking the tape, he was standing on the sidewalk.
They give me problems when you go to the property or?
Oh, they're like, oh, well, go ahead, kiss the pieces of shoe. I'm like, I don't care what you say, get off the property.
He calls now, we would like to say, oh, he called the hotel,
Yeah.
This is the right one. I don't think it's the right video.
What did they say?
saying like, you know, it's there,
No, this is the right video. So give me just 1 second.
Trying to keep this straight, Counsel. Is this still part of Stage 1? Or I don't know what this is.
No, Judge, I'm getting ready to mark this as an exhibit. I think it's the wrong video. It's a different video that I want to refer to.
And just for clarity, can I get clarification on which video was just played?
What was the number on the video that was just played? Just use the.
I think it was video 4.
Yeah, I think that's correct. Your Honor, I'm actually going to disregard that. It's not the correct videos. I'm not seeking immunity evidence this time.
Just, and I know I'll do it later, but the state is going to include it.
I'm sorry, I couldn't hear you there. Can you turn?
Sorry, Judge, and I know I'm not doing it now, but just for clarity, the state is going to move to admit that video into evidence. Now that it's been played, the foundation's been laid for it.
Just to advise both counsel, obviously we're playing videos.
I know you guys have already.
Pause that for a second. Counsel. We're playing videos and I'm watching them and I'm hearing them. But we're not being, I don't know what you all have agreed to and haven't agreed to.
I'm sorry, Judge. Before trial, we did agree
Okay, so,
to admission of.
and so I don't have a problem with
Right.
that, but obviously I don't mind, what the proper procedure is. Play a part, lay the foundation, move for its admission, as opposed to just playing the recording. That's why I'm assuming you all have probably stipulated, because I'm just seeing recordings being played without an admission.
And Judge, the last recording, I was trying to lay a foundation. It's not the correct recording. This is. So, again, I'm just going to play a couple of moments here to lay foundation with Officer
So can you, before you do that, can you tell me what exhibit, so that we can keep you straight, what exhibit are you, what, is this defense 1? or
This
what
would be
is-
defense 1.
Do you have a sticker? If not, I'll have to go get my staff.
Do you have any exhibit stickers?
No.
Is that marked?
It's marked for the case number. I can add the exhibit number onto it.
Yeah, can you just write the exhibit number, please, so that
Yes,
we can have a proper reference?
I'll lay the foundation while he's getting that ready. That's fine, thank you. And Officer Dare, I'm just going to play a few minutes here to see if you can confirm that this is the night in question, that you had this conversation, and that you in fact believe this is your body. Okay? I'm just going to play a few seconds here.
Pulled them from your property.
Is that your voice?
Yes, sir.
And do you recall having a conversation with this gentleman on the date and time in question?
Yes, sir.
And does this video fairly and accurately depict the events of that conversation with him to the best of your recollection?
Yes, sir.
Your Honor, I'm now going to move to admit Defense Exhibit 1 into evidence and publish.
I'm talking about statement by the defendant, but another person state.
Judge, the state's going to object to hearsay. I'm assuming at this point that this video is being admitted for the purpose of the statements by the security guard, being admitted for the truth of the matter asserted by the security guard in his out-of-court statements.
I don't have a problem viewing the video. I have a problem with it's. I presume this is a security guard, but statements now made by the security guard would be hearsay. I don't have a problem watching the video for context of where people are standing, but I believe it is hearsay in terms of statements made by the security guard.
Your Honor, I'm not going to be referencing directly any statements by the security guard. Again, the security guard, I believe, is present. He's going to testify. He'll be questioned about his own statements. The questioning here is going to be statements from Officer Adair and the officer with him regarding issues he's already testified to, essentially to refresh his recollection.
Is this security guard going to be testifying, you said?
He is. He's the gentleman who just arrived. Again, we're doing things a little out of order. I thought he was going to be testifying first.
Even if he testifies, counsel, how is his out-of-court statement on hearsay?
I'm not offering for the truth of what he's saying. I'm offering to show Officer Adair's interaction with him, the fact that he was confirming the property lines with him, and the fact that he said he didn't recall if the officer next to him asked about whether or not he was on the trespass list. This is to refresh his recollection as to whether or not Mr. Ruff was on a trespass list.
All right, for that limited purposes, I'm going to allow it. Go ahead.
If they are back on your property, do you want them arrested?
Yeah,
Okay.
we already told them to leave it. So they come back, yeah.
Now, where they are standing, at least the one, is that your guys' property?
On the edge, definitely. But even where the Burton is, where the sign is, that's our property. Okay. So basically everything off the sidewalk? Yep.
Yeah. So once you hit that driveway, the paved driveway is your property?
Yep.
Okay.
You want them on your lot or on trespass lot? Yeah.
So, obviously, there was an inquiry about wanting him on the trespass log, correct?
Yes.
So is it your understanding that Mr. Ruff was not on any sort of trespass logs before this date in question?
As far as I understand from that question, I would say so.
And officer, just for clarification, is that question posed by you or somebody else?
That question was asked by the other officers.
Thank you.
You weren't present for any conversations between Mr. Daly and Mr. Ruff, correct?
No, sir.
So you never observed anybody tell Mr. Ruff where the property line begins and ends, correct?
No, sir.
You yourself never told him where the property line begins and ends, correct?
No, sir.
Nothing further, Your Honor.
You do that?
play for you again the video that the council already played for you. Maybe.
What's that?
Come over here.
No, yeah. So yeah, they don't listen to us anyways. So.
Yeah, I already told them, no, you guys can't be on the property.
Alright.
What did they tell you when they told me to get on the property? Did they go over time?
Judge, I'll object. I'll raise the same hearsay objection as the state. This is not the video that was admitted, I don't believe. This was the one that I started playing inappropriately, but I believe these statements are hearsay.
Judge, this video's already been played for the court. It's already been played. That objection's been waived. Defense is the one that's played it.
I already heard this. I don't know from which.
It was when I was playing the wrong video to lay foundation. It hasn't been admitted into evidence. And a hearsay objection was raised by the state for statements that the security guard was making.
Well,
So
I think that was.
I didn't
that was
object to
on-
this video.
Right, it was
I
the
object to the other
it
one.
was the other video, and this was already played.
The foundation's already been laid.
So I already heard this.
it's a hearsay objection.
Right.
But I'm trying to understand how hearsay would apply to the statements made from one person in one video and not in the other. The state raised the objection.
Right. If you remember, they raised it, I overruled it, I allowed you to play it. Remember?
And correct. And if a similar situation occurs here, that's fine. But
Well,
for the record, I
it's
believe
not
this
about a
is.
similar situation, it's about the fact that it was already played and I already heard it, and it was based upon your request, where it's admittance. And
I
so-
did not request this admitted, I don't believe, Judge.
I'm not talking about this video, I'm talking
Okay.
about the content. What you said was, you wanted to show about whether or not this officer talked about boundary lines.
This is a different video, Judge. This was the video I started playing inadvertently.
No, I understand, but it's the same conversation, correct?
Correct.
So
It will be. It's not right now. This is not part of the same. This is not part of that video that was played.
Judge, the state's position is that hearsay objection has already been waived. Defense already played this into evidence. Just because it hasn't been admitted, the court's
Right,
already
because
seen the
if
evidence.
you've seen it, it's admitted. I mean,
To not let me now play it and address it is not fair.
I'm more looking at, I'm going to overrule the objection, what I'm looking at now for me is I'm looking for the location, the layout as to this. I mean, I know that the security guard, it's my understanding this person is about to testify, so I'm going to overrule the objection. I believe I've already heard this. I believe it was already played for me without objection, so I'm going to overrule the objection. Go ahead, Mr. Humphrey.
And to be clear, Judge, the state does believe the court should pay attention to the statements at this point. That it's been played for the court. There was no
I've
objection
heard
to
it.
the hearsay.
I understand. I heard it. Go ahead, Mr. Humphrey.
And officer, just for clarity on the record, is this your body cam?
Yes.
Is this a recording of the conversation you had with the security guard on the night in question?
Yes.
Have permission to come over here. Record, come over here. Have permission to come over here and record it. No, yeah, get off the property.
Sorry, I'm going to back up since the volume is so low.
So yeah, they don't listen to us anyways. So.
Yeah, I already told them, no, you guys can't be on the property.
Alright.
What did they tell you when they told them to get off the property? Did they go over trying to record him to come over here? Have permission to come over here and record it? No, yeah, get off the property.
Would they give you problems when you told them to get off the property here?
Oh, they're like, oh, well, go ahead, kiss the piece of shit. I don't care what you say, get off the property.
He called now, your life is
The
he called us out.
yeah, what are they saying?
They're saying like, you don't get scared, like,
Your Honor, I'll object to any statements the woman is making as hearsay. This was never played before. I'm not sure what her statements are. So there's a third person now speaking that was not on the portion that I played. So I'm objecting to that as hearsay at this point.
Actually can't really hear, but what's the purpose now, Mr. Hopkins? What are you trying to show me here?
And I guess I'm not clear, Judge, and maybe I've played it too far. I thought this was still a portion the defense had played when they played it previously.
I thought it was too. I thought I heard the female voice. I couldn't hear what she was saying.
And that was the state's position. I'm just trying to
go continue. So we will go ahead.
You guys are no trespassing property anyway. You guys trespass people left and right, so
Yeah.
it's not anything new.
Yeah, if you close this down, that's going to be a matter.
And perhaps maybe it was on the other videos that was played. But at some point you had this conversation with the security guard, correct?
Yes, sir.
Okay, and that is an accurate representation of the conversation and what the security guard conveyed to you.
Yes, sir.
I think technically this has already been admitted. Actually, no, this hasn't been admitted. The state would move to admit this as exhibit, I believe, up to 3 for the state judge.
Counsel, approach. So, can you, I still need the fence to go. I'm looking and see.
We have to flash drive all of the since
I just want to try to make sure that this is all of these admitted. You understand this?
All we put on was the body cam footage of the arrest and the body cam footage of the other interactions with the two that we did in the investigation evidence that was in the view and the other interactions.
Look at something in the evidence, it's an evidence, and if there's an appeal later on, that's it, I'm not.
Because that wasn't from the flash drive, that was from the internal hard drive on the computer. We transferred the ones we intended to admit onto the flash drive. So I'm confident if I go through, but we will confirm before there's an
So whatever the phrase is admitted, right? But yes, please confirm it's on the as far as what's given before. So I just want to keep it in possession. So what is this now? How is this different from what's on the flash drive?
I the body cam footage of the interaction with officers that happened to people, I believe is Beaver's Foundation and and once the gentleman testifies at the end of the case, she can really do so.
It's still not a good statement. I'm still not sure whether or not you're saying that. So what exhibit? Are you going to give me something?
I am. Let's see.
No, actually. Okay, that's fine.
If the defense is
All right.
stating-
Okay, stage 3 is submitted.
check, which is the very market. Figure out the only videos that should be on that's going to be a jury is the 2 that were admitted into evidence, okay? Or just the 1, if they already admitted the other.
Also, Adair, does someone have to be put on a trespass list before they can trespass on someone's property?
No, sir.
In fact, isn't that the point of the trespass enforcement program?
Yes, sir.
If an owner of a property or an employee with authority tells somebody, you need to get off my property, is that reasonable notice to get off the property?
Yes, sir.
Stage no further question.
Officer, you can step in.
Judge, state rests at this point.
Your Honor, I'm going to make a Rule 20 motion at this time. Your Honor, first and foremost, I'm not sure that the state has met its burden establishing what the property line is of this hotel. We had an officer testify to the property line that was there, but in reality, Judge, when we're dealing with an area that is not fenced in, that is not behind a door, a residential structure, something like that, we are talking about an invisible line on the ground where sidewalk and asphalt separate. There were no witnesses called by the city of Mesa. There haven't been any diagrams, any schematics, anything to demonstrate what the property line in fact is on that particular property. And whether somebody's trespassing or not, they have to actually be on the property line. All we've heard for evidence that a property line exists is an officer testifying that he was told by somebody else that this is the property line. The state has not presented any evidence that that is in fact the property line. And if we're being fair, I mean, we all took 2 semesters in law school where it's Blackacre spilling out 2 feet onto another property and the problems that come with it. These things do happen. So we're talking about whether or not a gentleman was standing on asphalt or sidewalk and convicting him of a crime based on that. The state has the burden to show where that invisible line in the ground is. They haven't done it. They have not presented evidence to demonstrate that there is in fact a line that this gentleman crossed. I'm asking for a Rule 20 motion at this time, Your Honor.
Thank you. Judge, obviously a Rule 20 motion is considered in the light most favorable to the state. In this instance, the officer has testified as to what the line was. There's a clear and distinct line on the ground. It's literally the difference between sidewalk and asphalt. There is a very clear, distinct demarcation between the sidewalk and the asphalt. The security guard clearly had a conversation with the defendant. The police officer didn't have to, but still had a subsequent comment of, hey, you need to step back. The defendant's response was, shut up, motherfucker. He didn't have any intention of getting off the property. He didn't have any questions about, well, what's the property line? I don't really know the property line. Could you tell me, officer, what the property line is? It was, shut up, motherfucker. I'm not interested in essentially conveying, I'm not interested in what the property line here is, okay? I'm not interested in you telling me what it is. I'm not interested in you and your courtesy warnings that I need to step back to get off the property. In the light most favorable to the state, the defendant knew what the property was. It's clearly marked. He went over the line. He stayed on the line after being asked by the officers, and he returned onto the property after the security guard had also told him he needed to get off the property. In the light most favorable to the state, the evidence clearly supports conviction in this case.
Given the testimony presented, the court is going to deny the defense's Rule 20.
Your Honor, the state's going to call Mr. Daly at this time. Or, I'm sorry, the state. The defense is going to call Mr. Daly at this time.
Okay.
He's not outside.
Oh, sorry, he's inside.
Oh, okay.
Sir, if you come forward, please. You can forward, come around the witness stand. Raise your right hand. You swear your right hand. You swear from the testimony that you're about to provide this court will be the truth and nothing but the truth. Yeah. Only God says so.
Good morning, Mr. Daly. How are you?
Good.
I really don't have a lot of questions for you. I'm just going to ask you a couple things and then we'll get going, okay?
Okay.
All right. Back on the date and time that this incident took
Yeah. Sure. I'd like to get his name, his full name.
Sorry.
Could you go ahead and state your name for the record?
It's Jason Daly,
Okay. And Mr. Daly, what do you do for a living?
security.
Okay. Where do you work for security now?
21st Century, 43rd Avenue, like that.
So can you give me the spelling of your last name?
D-E-A-L-E-Y.
D-E-A?
L-E-Y.
Thank you so much. So I have this right.
And any previous experience working security?
Worked security 17 years.
Where did you work before 21st Century?
No, this is 21st Century.
Okay.
I worked 21st Century, and I worked at the American Institute at private security.
Okay, so talking about that particular incident, do you remember an incident involving a gentleman named Christopher Ruff being on the property asking to record?
Yes.
Okay. And going back to that date and time, did Mr. Ruff and several other people ask you if they had permission to record on the property?
Yeah, they asked me if they had permission to record on the property. I told them you don't have permission to record on the property.
Okay. So after they asked for permission and you said no, what did Mr. Ruff do? Do you see Mr. Ruff? Let me ask first. Do you see Mr. Ruff in court today?
No.
Okay. I mean, if you don't,
I don't.
based on your recollection of the event, when you told them they did not have permission to record on the property, how did those individuals react?
Someone began the attitude, and I just explained to them that they can't record on the property. If they want to record, they can record off of the property. And after that, they asked where they could record on the property. I said they could record off the property over towards Burger King. That's when they walked over towards Burger King.
So they did comply with your
Yes.
request for them to leave the property, correct?
Yes.
Were you content with where they went to do their recording? Did you feel that they had complied with where they went to go stand?
Objection relevance.
Yes.
Trespassing, please.
Go ahead.
Did you feel that they had complied with your request based on where they were standing? If they were not complying, would you have then contacted them further and said, hey, you guys need to move further back?
Yes.
And after that, did you have any further interaction with Mr. Ruff for the rest of that night?
No.
No further questions, Your Honor. Thank you.
Ross?
Do you recall telling the police on that night that if they came back on the property, you wanted them arrested?
Yes.
And you would agree with me that you weren't watching every part of the property at all times that night to see whether someone came back on.
Yes. Watching every corner of the property.
I've never played this.
I'm sorry, Your Honor, I didn't catch the last answer he gave. I just couldn't hear him.
Would you just repeat what your answer was? Let me rephrase the question. Would you agree with me that you weren't watching every part of the property that night at all times to see if any of those individuals came back on the property?
Yes.
No redirect. Witness can be excused, Your Honor. Oh, okay.
Mr. Bailey, is, in terms of the property line, is the asphalt on the drive, is that part of the property?
Yes.
And I'm sorry, Judge, I missed the very end of your
I
question.
said, is the asphalt part of the property as you come into the entryway? Is that part of the property? That's all I have.
Judge, could I ask a follow-up question based on that? How do you know that that's the property line?
I talked to the property owner. The property owner when I first started our job. He could show me. He showed me the paperwork of the map of the property. He showed me with all the property. So that's how I know that's part of the property.
Okay, thank you.
Move forward.
I know, that's fine.
Okay.
No other way. Oh, let me just confirm with my client. Your Honor, my client is not going to testify at this time. Does the court want to do an admonition regarding that?
Counsel, I don't. I always trust defense counsel is competent, and they've
Okay.
gone through this with the defendant. I know some judges do that. I do not.
Then I will just formally put on the record that I have conferred with my client that it is his absolute right to testify or not to testify, that choosing not to testify can't be held against him, and I have just confirmed with him that he does not wish to testify in this matter, so the defense will rest.
You both? As far as witnesses.
Right. Judge, I'm going to just briefly recall Officer Hager.
You're gonna. I'm sorry.
Yeah, sorry, Judge, I'll try to speak up.
This is air conditioner. I
Yeah.
apologize. I don't know why it's so noisy, but
That's
I'm
okay.
having a hard time.
The state's going to just briefly recall Officer Hager.
Officer Daly, can you come forward? Let's go on to it. It's Officer Adair. 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 Either one. Okay.
What is it? It's from the county assessor works on the property line. He'll testify that he looked at the property line. He'll testify it's an accurate representation.
He looked this up?
That he,
Okay, all right.
Young Mayor Coach?
Yes.
Officer, I'm showing you what has previously been marked as state's exhibit number 3. Prior to trial, did you go on to the county assessor's website to look at the property that we're talking about today?
Yes, I did.
The exhibit that I've shown you, is that an accurate representation of the information off of the county assessor's website for that property?
Yes, sir.
And does it show the property line of the property in question?
Yes, sir.
And how is that shown on the map?
Blue line.
And let me just ask you this, does that blue line separate the sidewalk and the asphalt?
Yes, sir.
And when you say blue line, that blue line's not actually drawn on the ground, right?
No, sir.
Is it a line that's actually imposed by the county assessor onto the aerial view of the map?
Yes, sir.
Your Honor, the state would move to admit exhibit, I'm sorry, I think I named it 3, but I think it should be 4.
Stage 4.
Yes, Your Honor, the state would move to admit exhibit 4 into evidence.
Any objection?
No, Judge, thank you.
Nothing further, Judge.
Cross.
No, Judge.
Officer, you can step down.
State rest, Your Honor.
closing statement.
Thank you, Your Honor. Judge, in this case, the court's heard testimony from Officer Adair that he responded to the scene due to a large number of First Amendment auditors being present. When he responded, they initially moved the auditors off the property. Judge, you heard testimony and some evidence that the security guard there conveyed to the auditors that they could not be on the property recording, and conveyed to them they needed to get off of the property, and that he asked law enforcement to arrest them if they went back on the property. The property owner here clearly did not want individuals on the property. Officer Adair had contact with the defendant. He's identified him. During the course of that contact, even though he didn't need to, when the defendant came back on the property, that's trespassing. Okay? He's been told by law enforcement, he's been told by the employee of the establishment, he came back on the property. At that point, he trespassed. Officer Adair still very kindly asked him to please scoot back. The defendant's response at that point was, "Shut up, motherfucker." He had no concern about whether or not he was on the property. There was no confusion here. There was no, oh, I accidentally went on the property. It was, I don't care whether I'm on the property. You shut up. Don't tell me what to do. I'm going to go where I want. The idea that he accidentally went onto the property doesn't exist. It's a clear line. There's asphalt, there's sidewalk. The county assessor's website clearly reflects what the property line is. The employee testified that he knows the property line because he had a conversation with the owner who showed him the maps. The defendant clearly went on the property. He clearly went in violation of what the employee had asked him. He went in violation of what the officers had asked, and he went in violation of Officer Adair's courtesy request to scoot back again. He did not care that he was on the property. That is trespassing. Now, we can argue about degrees and things of that nature, but at the end of the day, the law doesn't recognize whether you are 3 feet on property or 50 feet on property. And if we do go down that road, it's an awfully slippery slope. The trespass is either the property line or, well, is it 3 feet? Is it 10 feet? When is somebody actually trespassing? In this case, he clearly went onto the property, and it cannot be any more clearly marked. He was asked by everybody involved to get off of the property in force. He was asked again by the officer as a courtesy. His response was, "Fuck you, motherfucker." I would add, Judge, that the statement in there, and I hope the court caught it, but you can hear on State's Exhibit 2, that the defendant essentially conveys what his goal is. He says in there, we're going to, or something to the nature of, confront and cause chaos. That's what he was there for, and that's what he did. But in the process, he trespassed, and the court should hold him accountable for that.
Does there have to be knowledge, though? Does it have to be knowledge that he's on the property? Would you agree, Mr. Marcus?
I would agree there needs to be a reasonable notice to get off of the property.
I'm not talking about, and I think that part is clear. I guess my question is, where it says knowingly entering or remaining on, I guess it's on the property.
Yeah, Judge, but I would argue that ignorance isn't a defense of the law either. And when an officer is asking you to scoot back, after you've been asked by an employee of the establishment and by other law enforcement officers to get off of the property, you can't willfully plug your ears and say, oh, well, hey, I didn't know. That's not a defense to trespassing. When people are trying to tell you, and they have told you, and they're asking you to, again, take a step back off of the property, if you don't care to hear, you don't then get to say, hey, yeah, look, I didn't know. You didn't want to know. You didn't care to know. You would think after so many, if there was really legitimately a concern, he had more than an opportunity to ask somebody, hey, what exactly is the property line? He didn't care. And when the officer tried to ask him to step back off the property, he didn't care to hear that either.
Judge, I'll answer your question with one word. Yes, knowingly is a requirement. It's literally in the statute. It's not ignorance of the law or ignorance of whatever. He has to know that he's trespassing to be found guilty of trespassing. It is a requirement of the statute. Okay? So first, I just want to note, and would obviously belabor the point much more if I was in front of a jury than a judge, but the reality is the state has the burden of proof in this case, and it's the highest burden that there is. Okay? So if you do have any doubt in your mind that knowingly was established in this case, then that is a not guilty verdict, Your Honor. And I want to be clear about one thing because it's important in this case. This case is a prime example of an opportunity to do the right thing under difficult circumstances. I'm going to be frank. Mr. Ruff is not a particularly likable guy in a lot of circumstances with how he interacts with the police. Even as I sit next to him here defending him, do I wish that maybe he'd be a little more respectful of the police? Sure, okay? He's there to confront and cause chaos. Okay, but that's not what he's on trial for here today. And it's very difficult, Your Honor, to distinguish between the fact that he used foul language with the police, that he engaged in a manner that maybe we don't like to see. I understand all those things, but that's not what he's charged with today. He's not charged with being rude to police. He's not charged with not handling himself appropriately. He's charged with criminal trespass. So I'm trusting the court a great deal and believe the court will hone in on the issues at hand regarding whether or not he knowingly was trespassing on a property. And the fact that you raised that question brings me to the most important point, that he didn't know he was on the property. And the best evidence of that was he went and asked for permission first if he could be on the property record. This demonstrates somebody whose mindset is not, I don't care what anybody says, I don't care what the rules are, as the state's trying to portray. He cares about what the rules of this private company have in place, so much though that he went and asked for permission to record. And when he was told no, according to Mr. Daly, he went to where Mr. Daly told him to go, and Mr. Daly was satisfied with where he was standing. At no point when he went to go continue recording the officers did Mr. Daly have a concern that he was trespassing. And he is the security guard on that property. Nobody's in a better position to make that call than him, certainly not Officer Adair. So the very fact that Mr. Ruff had the wherewithal to ask for permission shows that he knows that he needs permission to be on the property. And again, what we are talking about here, Judge, you saw the video. It's a matter of steps, and to be blunt, he never even broke stride. This arrest took place before he wasn't doing anything on the property line of substance. He moved a few feet to adjust his position and then was not told that he's now trespassing. I firmly believe, Your Honor, that this entire situation is mitigated if Officer Adair says, hey, that's the property line, you're stepping on it, you need to back up. But he doesn't. He gives an ambiguous order, just back up. Doesn't give a reason why, doesn't explain to somebody who doesn't know that he's even on the property line. He's focused on the officers at this point, Judge. He's trying to record what's going on. He's just walking as he's doing it. He's not walking on the property to make a point. He's there because he's distracted by what he's trying to do with the officers. He took one step on, and there's no evidence to suggest that if Officer Adair said, you're trespassing, that's the property line, take a step back, he wouldn't have done so. And we know that because when he went and asked, can I record on this property, and was told no, he complied. He doesn't have a lot of reverence for police. I understand that, and that's frustrating, but he has reverence for the law because he asked this company, do I have permission to be here? And when he was denied, he complied with everything they said, to the satisfaction of the security guard. It is also important to note that per the statute, the request has to be reasonable, okay? Now, in this particular case, Your Honor, simply saying step back in this situation is not a reasonable enough request. Step back because you're on the property line and you've been asked to leave. Perfectly reasonable. It didn't happen. Just barking at a guy, step back, is not enough, and it doesn't provide knowledge. There's no evidence that's been presented in this case, Judge, to demonstrate that Mr. Ruff knew that he was walking back onto that property line. And another thing that I think is significant, Your Honor, the city of Mesa created another boundary within the limits of this particular property line when they put up emergency tape, okay? And Officer Adair testified, Mr. Ruff never crossed that line. But when you're taking into account whether or not he knowingly was stepping on the property, at this point, they've put up bright yellow tape and created a barrier with that. He was focused on recording the officer and everything that was going on, all the things that these First Amendment auditors do. And in doing so, he approached the tape that was put up by the officers. That's not knowingly entering the property that he'd already asked permission to be on and was told to leave. That's a guy who ambled onto a corner of asphalt that anybody walking their dog in Mesa could have done. He wasn't paying attention. He wasn't knowingly entering the property. And when he did it, it was never brought to his attention. He was just ordered back up, and that was it. Knowingly is everything in this case, Your Honor, and you picked up on it yourself. There's nothing to suggest that Mr. Ruff knew that he was walking on the property. He was never warned that he was back on the property, and his past behavior in this case has demonstrated that if he was, he would have left because he did it already. And he did it to the satisfaction of the victim in this case. So based on the very high burden that the state has, and the fact that they have not proven that Mr. Ruff knowingly entered or remained on the property, and if he did, was not given a reasonable order to leave that, again, would help him know that he was trespassing, court cannot find him guilty in this case. There's just not enough there. The state has failed to meet their burden, in particular regarding the issue of knowing.
Mr. Hawkins?
Judge, the fact that the defendant had done it previously isn't evidence that he didn't know. It's evidence that he did. Okay? He was asked to get off the property by the security guard. He got all the way off. You could see it on the video. He was on the sidewalk. He knew what the line was. He got off when the security guard asked him to. When we see the video of Officer Adair coming over, he's clearly on the sidewalk by multiple feet. Okay? I understand counsel saying he has respect for law and he doesn't have a lot of respect for law enforcement. The problem here is his disrespect or lack of respect for law enforcement overrides his respect for the law, because he's off the property, he's on the sidewalk, he's clearly complied, and he clearly knows what the line is because he did comply. But then when Officer Adair comes over, we get that interaction and the confront and cause chaos comment, and then he steps onto the property. He clearly actively knows what he's doing. He's doing it intentionally. He's doing it to record the interaction. Officer Adair asks him to scoot back, and again, we're causing chaos. Shut the fuck up, motherfucker. He knows what he's doing. We know he knows because he was off the property. It is a clear line. The line could not be any clearer, Judge. We have natural lines in our property to denote this stuff. Sometimes it's a fence. Sometimes it's grass versus sidewalk. Asphalt versus sidewalk is also one of those. It could not be clearer. And he knew that, as evidenced by the fact that he was well off of the property line when he complied with the security guard's order. The problem was he wanted an interaction with a police officer. He wanted something for his recording, and so he caused it. He stepped on. He wasn't going to step off when the officer asked him to. He intentionally caused this issue. He intentionally trespassed. And we know that because of his behavior, because of his prior compliance. At this point, the court has to find him guilty. He knowingly went onto the property in violation and intentionally so that he could interact with a police officer in the court.
It's clear from the video evidence that Mr. Ruff came back under the asphalt. It's clear from the testimony that was presented under the asphalt in the entry and exit area as part of the property. I think it was reasonable for the officer to ask Mr. Ruff to step back. Did he tell him, hey, you're on the property again? But he said you need to step back. I think that's pretty clear. And did the officer say, hey, if you step on this part, you're on the property, if you're not on here, you're off the property? I don't know that the officer had to specifically state that. I think the asphalt is clearly, there's a clearly demarcation between the sidewalk and the pavement. Not struggling with whether or not Mr. Ruff was on the property or not. I know he wasn't because I can clearly see the video. I'm struggling because of the minor encroachment that he made on the property. I'm frankly both of them. That's my struggle. Did he know? I believe he did. He was told. And I think his response was reflective of the fact that I believe he knew how he responded to the officer. For that reason, the court finds that the state is not told. The court's going to find the defendant guilty.
Judge, I assume we'll be moving to not to the sentencing, but moving to the second trial at this point.
Yes.
Can the state have just a moment to step out and see who's here? Now, we also here be excused.
Yes.
you? Formally on the break. Or do you want to just like next one down? There's a lunch break in between this one and this one.
Okay. In favor? Yeah. Go for that, Mr. Hawkins. You can proceed.
What did you do for the blood disease of the flash drive?
Judge, this was marked and admitted, so I want to make sure you have it for the record.
Yeah.
I'm sorry, there's a lot of witnesses present for this one. Can I just get 30 seconds more?
All right, what I'm gonna do is I'm gonna step off there just for a couple minutes, okay?
Okay.
We are still on the record, we are now in case of State President versus Christopher Ruff, case 2410, case 3564, with a violation of 56. 21. Opening state.
And I'm sorry, Judge, I'm still having trouble hearing. Did you ask for opening?
I apologize, yes, opening statement.
It's stable wage, Judge.
Defense?
Defense will waive, Your Honor.
Mr. Hawkins, you may call your first witness.
Thank you, Your Honor. The state calls Mesa Municipal Security Officer Jason Moreno.
Raise your right hand. You swear affirm that the testimony that you are about to provide is the truth and nothing but the truth. And no sincerity.
When you're ready, Mr. Hopkins.
Could you please state your name for the record?
Jason Loretta,
Jason, where do you work?
City of Mesa.
And how long have you worked there?
In the municipal security capacity, I was there for about 4 years.
Okay. Is that the capacity you were working in back on October 6, 2021?
Yes.
Excuse me. What are your duties, or what were your duties in that role?
I was a security officer at the 20th Main at the Plaza Building. So I'm there to prevent any unauthorized access into employee areas, lock up at night, answer citizen questions, direct citizens around downtown areas that they're not familiar with.
Is the Mesa City Plaza Building, is that located in the city of Mesa?
Yes.
Can you just describe a little bit for us what the ground floor of the Plaza Building looks like?
Ground floor is the lobby, so there's human resources that connects from the lobby, the main lobby. There's a hallway to the east that leads to city clerk's office, a meeting room that city employees use, and a restaurant. And then east of that hallway is just an exit door that goes outside.
How many entrances are there to that central?
That main lobby?
Yeah.
So there's 2 public access points to that lobby.
Okay. And which sides of the building are they on? The east, west, or south?
They're on the south and the north side of the building.
Now, generally, when you are working in the Plaza Building, where are you located in reference to that property?
I'm at the security desk, and it faces the north entrance, which is the parking lot entrance, which is what most people use.
Back on October 6th, 2021, at around 11:30 a.m., did you come into contact with an individual who eventually became known to you as Christopher Ruff?
Yes.
Do you see him here in the courtroom? And if so, would you just point him out and describe what he's wearing?
You see it on the defense side of the plaid shirt.
Your Honor, would the record reflect that the security guard has identified the defendant?
The record is so reflect.
How did you first become aware of the defendant on that day?
I noticed 3 individuals walked in. Mr. Ruff had like a phone out in front of him. He was with a thin male and a heavy set male. The thin male asked to see city records. I tried to clarify like what records he was looking for, just in case he was looking for some specific like police records. I could direct him to the police station. And then Ruff eventually said clerk's office. Right? So then I
Sorry, you said what?
the clerk's office.
Okay, thank you.
City clerk. So then I called the city clerk, which is what I normally do, and I advised them there was a gentleman out here that would like city records. And then normally she comes out and speaks with them.
Okay. So in this instance, did she come out and talk to the defendant?
Yes.
What happened after that conversation?
Ann came out. They were just kind of walking around the lobby. Initially, they kind of went towards HR, and then they came back to me. But Ann came out. They kind of stood around her and were asking her questions, and it looked like they were recording her. I stayed at the security desk. I couldn't hear exactly.
When you say it appeared that they were recording her, what did that look like? I mean, what were they recording with?
I saw something strapped to Ruff's chest. I don't know if it was a GoPro or something strapped to his chest. And normally when people walk around like this, it's kind of like a emotional maybe it's how people normally do it with a phone.
In Your Honor, for the record, let the record reflect that the witness was holding his hands up like he's holding his cell phone in the back of it. Is that what the defendant was doing at the time?
I believe he was. I
But as far as him holding the cell phone up with his arms up like this, is that what you observed?
What's that?
Sorry, step forward. As far as him holding his arms up while holding the cell phone in this manner, is that what you observed him do?
Yes.
Is there, in that main lobby, is there a staircase?
Yes.
Okay, and where does that staircase go?
That staircase leads to the second floor, economic development. The second floor all the way from there is closed off. We need employee access to go there, but economic development has a door up there as well.
Okay. Now, generally, if somebody has an appointment with economic development, how does that go? Do they check in? Do they just walk straight up there? How does it work?
They check in at the security desk with their ID. I call up to economic development and confirm that they have an appointment. And then depending on what economic development is doing, they may come down and escort them up, or they may say, just go ahead and send them up.
And at that point, I assume you convey to the individual, okay, it's okay for you to go on.
Yes, because they identify themselves with their ID and they have city business, and the city knows about their presence there, and we have an appointment.
How does somebody know that they need to present their ID and check in before just going up the stairs?
There's several signs at the security desk and at the staircase. There's a sign on each side of the staircase saying stop. It's got a stop sign, or it says all visitors must register at the security desk.
And you mentioned that there were also signs at the check-in desk as well?
Correct. There's signs there. There's one in front of the desk. There's a sign on the door into the building.
Okay, so let me back in. So when you say there's a sign on the door of the building as well, is there a sign on the door entering on the north side of the building?
Yes. So from the parking lot, there's like a sticker on the glass.
Okay. And when you say sticker, do you know how big it is?
I can show you my hands. Maybe it's like
That would be fine. Okay. So we're not talking like a little 2-inch square.
No, it's like a foot by 8 inches or something like that.
That door that sign is on, is that the same door that the defendant entered into that day?
Yes.
Okay. So he walks through the door that had the sign on. Is that correct?
Yes.
When you step in through that door, is the check-in desk directly in front of you?
Yes.
And on that desk, are there signs that talk about needing to check in with your ID?
Yes.
And then if you walk past that check-in desk and those signs, are there also signs on that staircase that goes up to economic development?
There's a sign on each side of the staircase.
Oh, so there's actually 2 signs at the staircase. One on each side.
You have to walk through between them.
Okay. Okay, I'm going to show you, and I apologize, judges, I'm making these. Okay, I'm showing you. I'm showing you what has now been marked as State's Exhibit number 1. Do you recognize what that's a photo of?
Yes, this is the sign on the south side of the building on the glass.
So that's the sign on the south side of the building.
North side, sorry.
Okay.
The north side where the parking lot is where they enter.
Is that the sign that was on the door where the defendant entered the building?
Yes.
And you would agree with me that that sign reads, "Welcome to Mesa City Plaza. Visitors, please register at the security desk."
Yes.
Will the state move to admit exhibit only evidence?
Judge?
No, Your Honor.
Thanks, Ron.
I'm now showing you what his surface is. I'm now showing you what has been marked as exhibit number 2. You recognize what that's a photo of?
Yes.
What is that a photo of?
That's a sign that's posted to the security desk.
So this is one of the signs that's actually on the security desk.
Correct.
So after you walk through the door with the sign, is this sign visible on the desk?
I think that one is in the rear of the desk, so
Okay.
on the south side of the desk.
Is there something similar on the north side of the desk?
Yes.
And you agree with me that this sign says, "Welcome to Mesa City Plaza. Please register at the security desk."
Correct.
Then it's taken move to admit exhibit
There's two
number.
of those.
Sorry?
There's two of those, one on each side of the south side of the desk.
There's two of them, two on the south side of the desk.
Correct.
And how many are on the north side of the desk?
I don't know if that particular sign might be a different one.
Okay. During your time observing the defendant, as he was present in the lobby, walking on City Plaza, did he ever go to the south side of the desk?
Yes, that's where he spoke with the clerk, the city clerk and clerk.
And when he went to the south side of the desk, would this sign have been visible?
Yes.
And let's take move to admit exhibit number 2 of evidence.
Any objection?
No objection.
Case 2 is approved.
I'm showing you what has been marked as showing you what has been marked as state's exhibit number 3. Do you recognize that photo?
Yes.
Okay. What do you recognize that to be a photo of?
This photo ID required for each entry, and that's facing the north entrance.
So this signage faces the north side. When somebody walks in through the north side of the building, this is the sign they would see.
Yes.
And is there one of these? Is there more than one on the north side? Or are you not sure? Okay, that's right. You're on the state of move to admit exhibit number 3 into evidence.
Any objection?
No, Your Honor.
Case 3 is admitted.
I'm now showing you what has been marked as state's exhibit number 4. Do you recognize that photo?
Yes.
And what do you recognize to be a picture of?
The sign on the left side of the staircase.
So you said the sign on the left side of the staircase. Is there also a sign on the right side of the staircase?
Yes, it's the same sign.
Okay, so it's the exact same sign.
Correct.
So there's two identical signs on both sides of the staircase.
Yes, there's another pillar walk down on the right side.
And then now showing you exhibit number 5. Would you agree with me that that's just a closer photo of the signage that's on both sides of the stairs?
Yes.
Would you agree with me that this sign on the stairs says, "Welcome to Mesa City Plaza, stop, all visitors must sign in at the security desk, thank you"?
Yes.
You under the statement move to admit exhibits 4 and 5 into evidence?
Any objection?
No, Your Honor.
4 and 5 are admitted.
And again, for clarity's sake, that sign that says, "Stop, you must check in at the security desk," that sign is on both sides at the bottom of the staircase.
Correct.
At some point during your contact with the defendant, did he approach those stairs?
Yes.
And what happened at that point?
Started to go up the stairs, and then I said, "Sir, you can't go up there." Kind of stopped, turned around. I got out of the security desk area. I approached the staircase at the bottom. And I said, "You can't go up there." And he said, "Why not?" I said, "There's 2 signs here. It's for employees only. You have to register a security desk." I said, "It's a public building. I can go wherever I want." I said,
So let me stop you. So when you tell him he can't go up there, at some point during that conversation, he tells you it's a public building, I can go wherever I want.
"Yes."
What happened after that?
And I said, "Well, I'm telling you that you can't go up there." And he asked for the ARS code.
Let me stop you for just a second. When you approach him and you have this conversation, are you dressed like you're dressed today?
No.
Okay, how are you dressed?
At the time, I was dressed in a municipal security uniform.
Which looks like what?
It's a light blue shirt with BDU pants. Have a badge, my name, says Mesa Police, Municipal Security, a patch on my shoulders.
Okay. So clearly not just in normal civilian clothing at the time.
No, I should be pretty recognizable as security for the building.
Okay, so you have this conversation where he tells you it's a public building, I can go wherever I want. What happens at that point?
Proceeds to go upstairs.
At this point, when he proceeds to go up the stairs, the minute he starts going up those stairs, is he bypassing that signage that says stop?
Yes.
And you've already told him you can't go up there, correct?
Yes.
What happens after that?
I then get on the radio, call for a police officer. The other gentleman, 2 stayed downstairs. One was following me with the camera. I got on the radio.
So there were other gentlemen there recording as well?
Yes, there was 2 gentlemen with him.
Okay.
But they didn't go upstairs.
So the 2 individuals that were with the defendant, did they come in with the defendant?
Yes.
They did not go up the stairs.
No.
And presumably they observed the same signage, and were they within earshot when you had your conversation with the defendant?
Yes, they were recording it.
And they never went up those stairs,
No.
but the defendant did.
Yes.
So you call for the officer. What happens after that?
I believe it was just a few minutes pass, and then the officer comes in. I quickly tell him, "Hey, they went upstairs," after I asked him not to, and then Mr. Ruff was coming down at that time.
Does the Mesa City Plaza have cameras in it?
Yes.
Okay. Sorry, Judge, I must have played this thing 6 times yesterday to make sure it's going to work. It's thinking, so. It just takes time. It is working on my laptop, and I'm just waiting for it to catch up to the projector.
You know, Mr. Hopkins, I don't know if it matters. Is it an issue with the projector now?
Oh, good call, George. I forgot to switch to the dock.
There you go.
Well done. Okay, sorry about that. Mr. Moreno, do you recognize this, what this is a video of?
Yes.
Is this the Mesa City Plaza?
Yes, that's the south entrance to the lawn.
And I would draw your attention, I don't know if you can see it from where you're sitting, but the bottom of this video has a time of day and a date of October 6th, 2021. Is that the date of this incident?
Yes.
You may not be able to tell, but in the top right-hand corner, is that your security desk?
Yes.
Okay. You can't tell if that's you or not, can you? Not from the video itself.
Wouldn't be anyone else.
Okay, all right. So I mean, you can, but from the video itself, you know, it's not
It
entirely.
looks like a silhouette.
But for our purposes, that is the security desk, and in the background behind your desk, is that the north doors to the building?
Yes.
Okay, is that the doors the defendant would have come through?
Yes.
Now on that security desk, I showed you previously pictures of signage on the left and right side of that desk as we see it. Is that where those signs are stationed that say you must check in with ID?
Yes, on the south side of
Right,
the
on
desk,
the
you
south
see
side.
a little white rectangle on both sides.
Okay.
of the desk.
And then similarly, when we're looking at the staircase at the very top of the screen, there's two sort of little pillars there. Is that where the signage is that says stop, you must check in?
Yes.
Okay. The individual you see in the picture right now, is that the defendant?
Yes.
You can see him start to go up the stairs. At this point, what do you do?
I said, sir, you can't go up there. He stopped, turned around, and then that's when I approached
Okay.
the staircase.
And we see two other individuals in the picture. Are those the individuals that were with him?
Yes, that's the heavy set one. I can't see the female.
Okay. So at this point, is he still standing right there on the stairs, or has he gone up?
We went up the stairs and then I got on the radio.
So this isn't like he went up the stairs for 3 seconds, turned around and came down.
No.
Who just came in the north doors? If you know.
Officer Brown.
And now was that the defendant we just saw come down the stairs?
Yes.
Okay, I'll back it up for you. So again, is that the defendant coming down the
Yes.
stairs right now? Is he recording the signage at that point? Do you know?
He recorded it earlier,
He recorded the signage earlier.
right in front of it.
And the state would move to admit exhibit, Judge Mesa, I don't see what we're up to.
Yeah, 6.
6. State would move to admit exhibit 6 into evidence.
No objection. No objection, Your Honor.
Judge, the state doesn't have any further questions for this witness at this time.
Thank you. Cross-examination?
Yes, Your Honor. Mr. Moreno, in your experience as the security guard or should I step up? Maybe it'd be easier.
Just 'cause it's so loud.
just a little bit louder. Mr. Moreno, in your capacity as the Mesa Town Plaza security officer, are you aware of the difference between a public and a private building in regards to the laws that govern each one?
Yes.
You are familiar? So to your understanding, what is the difference if it's a public building as opposed to a private building?
The public can enter in a private building, it's not like a business, somebody owns it, it's not government related.
Okay. And was this building, the Mesa City Plaza building, a public or private building?
The lobby, the first floor is public. So it's a public building, the first floor is open to the public.
Okay, the first floor is open to the public, correct? So the second floor and beyond would be unauthorized, is that fair?
Unless you have city business,
Then it would be authorized, correct? But unless you have
After
city
you check
business, the second floor and beyond are the unauthorized areas, correct?
yes.
What is the purpose of having those areas be unauthorized?
Objection calls for speculation. I also object to the evidence.
You would, I can rephrase.
Just ask, do you specifically know why they're unauthorized? That's just the yes or no.
I'm just told where the public has access to, and that's it.
Go ahead and move on.
You'd agree that the offices, all the public offices, they are on the second floor and beyond, correct? There's no office that is on the first floor to safeguard, correct?
There are offices on the first floor. City clerk's office is locked. You can't just walk into that one, but you can walk into each one.
And that's on the first floor,
Correct.
which is, based on your testimony, that is authorized to the public, correct? And there's no issue with any individual being on the first floor, correct?
Correct.
And the other individuals that Mr. Ruff were actually with, they walked around the first floor, bypassed your security area, desk, themselves as well, and walked around to the first floor, correct?
And one of them even walked down the hallway.
Another one did, correct? Now, to your knowledge, Mr. Ruff was the only one that was arrested that day, correct?
I know.
So, at any time during your interaction with Mr. Ruff, from beginning to end, did you ever physically see Mr. Ruff on the second floor?
No, I was not on the second floor to see him up there.
So, from your vantage point from the first floor, you could not tell whether or not he was actually on the second floor or not. Is that fair?
Correct. He went towards it, disappeared around the corner.
Maybe it would help if you explained the stairwell
Yes.
a bit, how it's designed.
Right, no, so there's about like 8 steps to it's a level or a landing, let's say. 8 steps to a landing, you turn left, which is south, and then you walk up more steps to another landing, and from there you turn towards economic development and walk to another flight of steps. So I didn't physically see him on the second floor because you can't from the first floor, but I saw him go up the stairs and disappear.
And just to confirm, so there's a flight of stairs, flat area, another flight of stairs,
With the flat area.
with another flat area.
A smaller flight of stairs that go up.
So
to the
3
second
flights of
floor.
stairs to get to the second floor, is that correct?
Yes.
And would you agree that there are no offices in the stairwell, obviously?
Not in this area.
Not in the stairwell, so to your understanding, the only, the subsequent offices would have been on the second floor, or as you mentioned, there were a few on the first floor. But when you saw Mr. Ruff enter the stairwell, from your vantage point, you could not see whether he had actually entered the second floor, and there are no offices in that stairwell throughout these 3 different layers, correct?
No, I couldn't see that.
Okay, so you don't know whether or not he did or did not?
I do know because I heard later on from employees up there that
It's going to be hearsay, Your Honor, you know,
Let me ask him.
So yes, if I knew.
So the question is, did you later learn assist the restaurant?
And I'm sorry, can I just change the question again, Judge? I didn't quite hear it.
The question, I believe, I'll paraphrase, was whether or not you knew, right?
correct.
Whether or not you'd gone into the offices, is that right?
Right, or whether, no, rather, are you able to confirm whether or not Mr. Ruff stepped foot on the second floor?
In total,
Correct.
eventually, yes. I heard that he did.
You heard that he did, but I'm saying you physically did not
I did not
witness it.
physically witness.
Okay, that's all I wanted to clarify. Now, the state showed you some exhibits with some signs, correct?
Yes.
Do you recall what those signs stated?
Some of them, they're all the same. The ones near the staircase, he just showed them. It said stop, please register at the security desk.
You would agree that none of the signs articulated the consequence of not stopping, if you will?
I would agree with that.
You would agree with that? So we saw a sign that says, please sign in. We saw a couple of those, do you recall?
Yes.
Okay, and then we saw a sign that stated to show ID, correct?
Yes.
So if an individual comes into that office without an ID, are they turned away?
Generally, it really depends.
So there are instances where they're not turned away, and there are instances where they are. What is an instance where they would not be turned away, even if they don't have an ID?
Because I know who they are and I deal with them all the time on a daily basis, and they have city business constantly, so I know who they are. I've seen their ID before.
So absence, you knowing who they are, if they don't have an ID, are they not allowed in the building?
They're allowed in the building.
So
The lobby is open
where
to
does that
everyone.
restriction begin?
Like I said, the first floor is open to anyone.
And again, you can't confirm that he went beyond or went onto the second floor, correct? Just to clarify.
Just the staircase and then disappeared, and I couldn't see him anymore. I did not see him, physically see him on the second floor.
Are there instances where somebody would come in to make a anonymous report?
And on this report,
Correct. If there are government entities and buildings in that building, maybe has there been an instance where somebody may want to make a complaint or a report but wishes to remain anonymous?
Objection notice, sustained.
If somebody comes into this office or comes to your security desk and does not present ID to you, they're still free to roam around the first floor, correct?
yes,
Okay. So those signs only become relevant in going to the second floor and beyond, correct?
correct.
And you stated that after Mr. Ruff was walking up, he stopped. That's when you told him you can't go up, correct?
Yeah.
Any further? After that, you stated that you saw him continue to go up?
Yes,
You physically saw him continue to go up those stairs?
yes,
Okay. But you did not see where he ended, correct?
correct.
Okay. And to your knowledge, while he was on the stairs, did he have a conversation with anybody else?
He might have said something to one of his friends that were there, but he was mainly talking with me.
And you'd agree that there was another friend there with him at the time?
There was two other individuals that entered the building with Mr. Ruff. They were still on the first floor. One was recording him.
Let me just check one other thing, Your Honor. Your Honor, I don't think I have any further for this witness.
Thank you, just briefly.
When you told the defendant he couldn't go up those stairs, any indication from him that he didn't understand what you were saying? In fact, based on your previous testimony, his response was effectively, it's a public building, I can go where I want.
Yes.
I've done the privilege.
So you can step in. This witness may excuse.
Judge, I'm going to ask him to remain just outside in the hallway.
Okay, thank you.
Your Honor, the state's going to call Anne-Marie Fantasia.
Could you come forward, please?
Oh, nothing.
Oh, no. Oh, sorry.
You could come around to the witness stand. swear from the testimony you give about to provide you with the truth and nothing but the truth?
Yes.
Lord of Christ.
Thank you.
Would you please state your name for the record?
My name is Anne Marie Fantasia.
And where do you work?
I work for the city clerk's office for the city of Mesa.
Is that located in the City Plaza building?
Yes, it is.
Can you spell your last name for me?
Yes, F as in Frank, A and as in Nancy, T as in Tom, A, S as in Sam, I, A.
Thank you so much.
Were you working on October 6th, 2021?
Yes, I was.
At some point on that day, did you come into contact with an individual who eventually became known to you as Christopher Ruff?
Yes, I did.
Did you see him here in the courtroom, and if so, would you just point him out and describe his rank for the judge?
He's the defendant in the white plaid shirt.
Now, would the record reflect that the witness has identified the defendant?
Record will so reflect.
How did you come into contact with him?
I was contacted by our security officer that there was someone in the lobby seeking public records. When I went out to the lobby, or before I went out to the lobby, I wrote down the web address to our public records online request because we get these requests often. And there was a gentleman that I met with, and he was on his phone and he was asking me about the trespassing laws that we have for the city. And I explained to him that we don't have that information. I handed him the note, and then at that time, two gentlemen, one of them being the defendant, had come from behind and came around, and they were recording me on their phones. They were, do you want me to go on?
I'll lead you through some questions. So the information they were asking for, that's available online, it sounds like?
You can request the information online.
Okay.
Yes.
And is that what you conveyed to them?
Yes.
At some point, did you finish that conversation with the defendant and the people who were with him?
Yes.
What happened after that?
After that, the defendant started walking over to where there's a staircase leading to the second floor and started going up the stairs.
What happened when you started? So to be clear, did you personally observe this?
Yes, I was still in the lobby.
Do you recall where you were standing when you saw this?
I was standing across from the stairs, directly across from the stairs.
And the reason I ask is because, and maybe I missed it, but we looked at some surveillance video that kind of points at the stairs. And unless I missed it, you're not visible in that video. But if I understand you correctly, if the stairs is over here, you were on the other side of the lobby?
That's correct.
Okay. So you may have been outside of the view of the surveillance videos.
Yes.
Okay, when the defendant starts going up the stairs, what happened?
Officer Moreno had told him he needed to stop, that he didn't check in like they're supposed to when they enter the building, and he needed to come down the stairs. That's employees only up there. And the defendant started questioning the officer as to why he couldn't go up there and ask what Arizona Revised statute states that he can't go up the stairs. And at that time, Officer Moreno posted.
Objection, Your Honor. Hearsay.
And again, Judge, she's relaying an event that she observed. She's not admitting anything for the truth of the matter asserted. She's admitting what she observed happened. The event.
This goes to the state of mind. Go ahead. Go ahead.
Oh, I'm sorry. Officer Moreno pointed to the sign at the bottom of the stairs that says visitors must check in with the security desk, and said he can't go up. And the defendant was talking and saying a lot of things that I don't know. I was confused about what was going on, but the officer clearly indicated don't go up, and then the defendant turned around and started heading up the stairs, reaching the first landing. And again, he was told not to go up there, and he turned to continue up the second set of stairs, and that's when I left and went back into my office.
At that point, why did you leave?
I was nervous about the situation that was going on. We've had another incident prior to somebody coming in the building, and we have a safety concern.
So, I guess really what I'm asking is, as far as people going up that staircase in that manner, and after being asked by security, that doesn't often happen?
No, we only see employees going up the staircase. I've been in that building over 15 years, and I haven't even gone up the staircase because there's no reason for me to.
But at some point, you decided to leave because you were uncomfortable with the situation?
Yes.
I have no further questions.
Cross-examination.
Yes, Miss Fantasia. Just a few, actually. So, you stated that you saw Mr. Ruff go up the first, as we made clear, there's 2 separate landings, and then you get to the second floor, correct? So we have 3 flights of stairs and 2 flat landings that you have to go all the way up to actually be on the second floor, correct?
That's correct.
Correct. And you at no point actually saw Mr. Ruff on the second floor, is that correct?
I did not see him reach the second floor landing.
Correct.
Correct.
So the entirety of the area that you witnessed Mr. Ruff along that stairway, there's no offices in that stairway, correct? Where you observed Mr. Ruff?
In the staircase itself, there are no offices.
There are not. Okay. And again, when you had a conversation with Mr. Ruff, that was when he was on the first landing, correct?
My first conversation
Correct.
with him, no, that was in the lobby.
And then your subsequent one was on the first landing?
I didn't have conversation with him directly on the landing. It was Officer Moreno.
Okay, so you had no communication with Mr. Ruff as he moves from the first landing or goes from the bottom of the stairs to the first landing, or for the first landing any higher. You had no conversation with him, correct?
No, just observed.
Okay. And again, to clarify, you never saw him enter the second floor?
That's correct.
I have nothing further for this witness, Your Honor.
You're right.
Nothing further, Judge.
You just said that. Yeah, this witness is excused.
And Judge, unfortunately, I'm going to ask her to remain as well. Actually, Judge, you know what? She can be excused.
All right, you are excused. Unless the defense wanted to.
No, Your Honor. No, Your Honor.
You can be excused. You can remain if you wish, or you're free to go.
Thank you.
Thank you.
The state's going to call Celine Coach.
Come around to the witness stand. Raise your right hand. You swear affirm that the testimony you give about the life you spoke will be the truth and nothing but the truth.
Could you please state your name for the record?
Celine Coach.
I'm sorry, I did not catch that. What's your first name?
Celine Coach.
Can you spell your first name and your last name?
C-E-L-I-N-E. Last name K-I-L-I-C.
I'm sorry, K-Y?
K-I-L-I-C.
K-I-L-I-C. Thank you.
And Celine, the air conditioning is really loud in here. Well, you're just going to probably have to speak up so everybody can hear you. Where do you work?
I work at the City of Mesa office of economic development.
Okay. And how long have you worked there?
Coming up on 12 months in June, so 11 months.
Were you working on October 6th, 2021 at around 11:30 a.m.?
Otherwise, yes.
Where is the Office of Economic Development located?
So we're situated on the second floor.
At times in your work, do you have people who come to the City Plaza to meet with folks in the Office of Economic Development?
We do, yes, but they're scheduled appointments.
They're scheduled appointments? Okay. And then when someone shows up for a scheduled appointment, how does that generally work? Do they check in downstairs and then they come up? Do they walk straight up? How does it work?
So they're instructed to check in with the security guard, and the security guard will call our office and let us know when we're picking up.
Okay, and then you go down and you escort them up?
Yep.
Yes. On October 6, 2021, at some point did you become aware of an individual on the premises who was recording?
Yes.
Okay. How did you become aware of that individual?
We were walking out of our office to go to lunch.
Okay. And so when you walk out of your office to go to lunch, is there a back door? Do you go out the front and go down the staircase? How does that work?
We go out the front and down the staircase.
So when did you first become aware of the individual?
As soon as we walked out. Because we, like I said, we usually went upstairs. So our initial reaction was to see how we can help. But then we realized that he was recording. So.
You said we. Were you with somebody?
Yeah, my colleague Will Collins.
When you first encountered the individual, where was he at?
He was on the third flight of stairs.
Did you have any interaction with the individual at all? What did you guys do when you observed him there recording, or what you believed was recording?
We turned around right away, went back in.
And why is that? I mean, why didn't you engage or talk to him or something of that nature?
We felt unsafe.
What about the situation made you feel unsafe?
That it was an unexpected guest from upstairs.
So this was out of the ordinary. When you turned around and went back into your office, what did you do after that? Anything?
So we called security right away to make sure that they were aware of him in the building and they were on it.
I don't have any further questions, Judge. Cross-examination.
Yes, Your Honor. Ms. Kilch, I just have one or two questions. Keep this brief. I want to clarify, when you saw Mr. Ruff in that brief encounter you had, he was not on the second floor, was he?
He was about to be, but we turned around, and so.
So when you say about to be, he wasn't actually on the second floor? I just want to be very clear about that.
I don't know.
Did you, with your own eyes, see his feet on the second floor?
Not on the second floor, but on the stairs approaching the second floor.
Okay. Nothing further, Your Honor.
It seemed like you started to. I'm sorry, Judge. You turned it over to me.
Yes.
Okay, sorry. It seemed like you were about to say something there. You saw him on the stairs. Was he near the second floor?
Yes.
Okay. When you saw him, though, at some point, it sounds like relatively quickly, you turned around and went back into your office, correct? Do you know with any kind of certainty whether he continued up the stairs and actually entered the second floor or not? He could have. You just didn't see it one way or the other.
Yes.
I didn't think you.
You can step down, may this witness please do?
She may.
Defense?
Yes.
Okay.
No.
You are excused. You can remain if you wish or leave for you. Thank you.
State's gonna call no requirement.
Come forward for me, please. So you come around to the witness stand. Yes, thank you. You just may stand for a second. Raise your right hand. you swear from the testimony that you would have provided to support the truth and nothing but the truth?
Yes.
Go ahead and grab a seat.
Would you please state your name for the record?
My name is Lori Collins,
Ms. Collins, where do you work?
the city of Mesa,
And where specifically?
at 20 East Main Street,
And what department?
economic development.
And is the Department of Economic Development located on the second floor of the City Plaza building?
Yes.
Just to speed things along, is there a set of stairs that leads up to your department?
Yes.
Does that stairs go from the lobby up to the second floor where your department is located?
Yes.
Were you working on October 6, 2021 at around 11:30?
Yes.
On that date and around that time, did you become aware of an individual who looked like he might have been reported?
Yes.
How did you become aware of that?
My colleagues and I were leaving our suite to go to lunch, and before we got to the stairs, we noticed someone coming up the stairs who was talking to his phone and had something strapped to his chest.
What did you do at that point?
It was alarming, so I told myself and my colleagues and I to go back into our suite.
Why was it alarming?
Because it was very out of place. You have to, usually when people come to our suite, they have an appointment and we're aware of that.
And in this instance, you weren't aware of anybody who would be appearing for an appointment? What did you do when you turned around and went back into your office?
We called security
And why did you call security?
because I was scared.
If you had to estimate the amount of time you actually observed the individual who was reporting, how long?
It was a few seconds,
Just a few seconds?
just enough to notice something was out of place.
From what you've said so far, it sounds like it's not often that individuals just randomly come up those stairs without having an appointment.
Correct.
Stays open for questions, Judge.
Russ?
Yes, Ms. Collins, just a few. To clarify, you never saw Mr. Ruff on the second floor, correct?
On our floor, the second floor?
Correct.
Correct.
You did not see him, correct? On the second floor, I just want to make that clear.
No.
You did not, okay. When you saw him, what part of the stairs was he on in that brief few seconds that you saw him?
He was on the landing, facing our suite, coming up the stairs. So there's another flight of stairs that comes up to our office.
So there were still approximately 8 or 10 stairs, or a number of stairs he had to go up to actually make it on to the second floor.
It's just a couple of stairs.
Okay, but there was a distance he still had to go upstairs to actually make it on the second floor. Is that fair?
Yes.
And you never, obviously, again, just to confirm, you didn't see him actually do that, correct?
I'm having a hard time hearing you.
I'm sorry. Just to confirm, you never saw him actually make it all the way up to the second floor, correct?
Correct.
And the area that you saw him actually physically on has no offices in that exact area to safeguard, correct?
Well, the only office is our office. that
Which is on the
to
second
stairs.
floor, correct?
Correct.
Okay. Nothing further for this witness, Your Honor.
Thank you, Your Honor. Is it possible the defendant made it up to the second floor and you just
Hearsay, Your Honor. Speculation.
I'm not asking if you did. I'm just asking if it was possible.
Still speculation, Your Honor.
Go ahead.
Is it possible that the defendant came up onto the second floor and you just didn't see it?
Yes, because he was walking towards and we turned around and went back into our suite.
So at the time you turned around and went back in to call security, he was actually walking forwards.
Yes.
And by forwards, we mean up the stairs.
Yes.
I have no further questions, Judge.
Sit down. And this witness be excused as well?
Yes, Your Honor.
Defense?
Yes, no objection to that.
You are excused. You may remain in the courtroom or you free to leave.
Then the state's going to call Officer Christopher Brown.
Your Honor, we're going to move to preclude. We attempted to set up an interview multiple times with Officer Brown to no avail. And we may wanted to have put on rebuttal witnesses. We have no idea what his testimony is going to be. We reached out multiple times to Mr. Hawkins' legal aid to set that up. She attempted to. We never received a response. So we'd move to preclude Officer Brown's testimony.
Approach, please. Go ahead, please. Is this person, I apologize, there's different cases, is this the person where there's going to be, is that, there's going to be a request for deposition for that?
I think ultimately did get us to the hospital, so that's not an issue. They really want to call it.
Okay, did you file, a motion for deposition of Officer Brown?
We filed a request to the executive process.
No, I understand you filed, I understand you made a request for him, did you file a motion for deposition? Just a motion for that. I'm sorry, who indicated? Let me ask you this, when he said this, did you think he said this case of fraud? So okay. So we said this, I said around, this was said in February. 90 days is what I gave you. And so the request really is about 6 weeks ago, which I understand not, but I'm just wondering what it is in the motion file because to ask for deposition. Would you cancel that if you are you know, refused, so I'm just going to basically refuse it. Because you know, because we still do the business. So that's why we filed on this one. If you know about your circumstances, so if you look at 15.2, it says, the party of the business may file a motion request for local voting determination of the person. Under the following circumstances, the party shows that the person's testimony and material for the case are necessary to evaluate the defense, investigate the defense. Let's see, the person was able to set up preliminary cause surprise. And that person will not cooperate with the person.
It's a disclosure.
I don't understand, but if you're unable to get it in, you cannot believe that to address the deposition before you move to the testimony.
The way to have your rules is the way to have the party. Since that's not the case, it's not the party that has to do it. The party is the state. So
request for the court. I understand that he believes that there's no violations in it. This is something that I think I really wanted to address with this, and Judge Ryan, a hard time with that, we simply file a motion with the court and asking for a deposition for a date and time on the energy request for the court. We would have a difficulty setting that in. I believe that would be appropriate. We would find that we can do that, and then maybe we'll try to conclude and file a motion ahead of time. You're asking me now as the state is going through this, would you believe it was incumbent upon me if you knew this person was a witness, to at least file a motion with the court, simply asking for a deposition of easily managed or possibly a request for a easy revenge, but that's just like there was a request made for an officer there. Or at least, I don't know if there's actually a motion filed, but still, there's 6 cases, right?
Really, just need
I'm going to do a request on the officer to testify.
State calls on Chipper.
Raise your hand, sir. Please swear from the testimony that you're about to provide to the truth and nothing but the truth. Yes, sir. Go ahead and rest in peace. Mr. Hopkins?
Thank you, Your Honor. Could you please state your name for the record?
I am Officer Christopher Bratton.
And where do you work?
I work for the City of Mesa as a patrol officer currently assigned to the Central District.
Were you on duty on October 6th, 2021, around 11:30 a.m.?
Yes, I was.
At some point, well, let me ask this: what was your assignment that day?
That day, I was assigned as the police officer at the City of Mesa Plaza building at 20 East Main.
At some point, did you become aware of an individual that was going up the stairs in the Plaza building?
Yes.
How did you become aware of that?
I was notified over the radio that after I had left the building, a group of individuals had come in, and the on-site security requested me to come back for that.
Okay. In case I didn't, I think we already established this, but in case I didn't, is the Plaza building located within the City of Mesa?
Yes, it is.
So you were off-site at the time you became aware of this situation?
Yes, I had just left for lunch.
What did you do upon hearing about it?
I got back in my vehicle and returned back to the scene.
At some point, did you come into contact with an individual who became known to you as Christopher Ruff?
Yes.
Do you see him here in the courtroom? If so, would you just point out and describe what he's wearing?
He is sitting at the table over here in the usher.
Would the record reflect that the officer has identified the defendant?
The record is so reflect.
Where was the defendant when you came into contact with him?
The defendant was, as I was coming in, I believe he was coming down the lobby stairs from the second floor back to the ground floor.
To your knowledge, is just anybody allowed to go up those stairs?
No, those stairs have signage saying that you're not allowed to pass them without properly checking in security.
Did you subsequently contact the defendant?
I did.
And what happened at that point?
The defendant and several other individuals were beginning to cause a scene. My role being assigned there was simply to maintain order of the public space, and I asked them all to leave the premises.
And what happened?
They asked if they were being ordered to leave under the threat of arrest. I told them that they were being ordered to leave, and eventually they all left.
Did that effectively end your contact with the defendant at that point?
Yes.
State has no further questions.
Officer Brown, when you arrived on scene, actually in the City Plaza building, you never saw Mr. Ruff on the second floor, correct?
I did not see him on the second floor. No.
Correct. So when you had actually arrived near the stairwell, he had already been coming down, correct? And almost off the stairwell down to the first floor.
He was coming down from the area of the second floor to the first floor.
Okay. So when you saw him, he was on his way down.
Correct.
Now, due to you having worked here at this building or been assigned to this building before, do you have any knowledge whether or not this building is a public or private building?
The building is a government building with access to the public.
Okay, so it's a public building, correct?
It's a government building.
Correct. So it's not classified as a private building. Is that fair?
No, it's a government building.
So it would not be a private building. Is that correct?
It's not public in the sense that anybody can just walk in and do whatever as they please.
Correct. But anybody can be on the first floor, correct? As we've established.
To conduct business, yes.
And your only interaction with Mr. Ruff was entering, seeing him almost already down onto the first floor, and that was it. And then
he was not already almost down on the
Where
first
was he
floor.
exactly when you saw him?
He was coming from the second floor. As I came in, I watched him come from the area of the second floor, walk down the stairs, past the signage to come back onto the first floor.
Is it fair to say the layout of the stairs, you can't see the second floor from the first floor?
Correct.
So you don't know that's where that he had actually been on the second floor and coming down. You just know he was on a part of the stairs and eventually made his way down to the first floor.
Yes.
Nothing further, Your Honor.
Read your right.
I've never
Sit down. And this witness be excused?
Yes, Your Honor.
Officer, you're excused.
Thank you, sir.
Stay.
Your Honor, the State calls Detective Gardner this evening.
Your Honor, same objection. We just want it clear for the record. Mr. Gardner also did not respond to any requests for interviews. We just want that on the record.
You just said, just like, so do you swear from the testimony that you're about to provide this court will be the truth and nothing but the truth?
Yes, I do.
Would like to grab a seat, counsel, first, please. Well, I can tell you that practice counsel, I've done many cases also from the most serious to the misdemeanor, of course. If I believe somebody's going to testify, there's going to be large obligations of those. That's misdemeanor practice because I thought it was different deal when they testify, not waiting until the second day. I was witnessing, I understand they didn't disclose it, you all didn't know, you all were told they were not going to class or something. I know they were going to prosecutors on this case, or probably all the witness, somebody else. I don't know what the conversation was. They were telling me that it was confirmed to you that these people were going to testify. So when you said that was your impression, who's giving you that impression? Yes, I don't know if that answers that question. We need talking to a prosecutor.
It was so off the cuff, Judge, I didn't speak for sure as to what exactly was said. I think really was just even blocking other interviews. Could have been some reasons that interview. I don't remember the context enough to say that I was lied to. Honestly, I don't know. I could not say. I'm not doing that.
Sorry,
I mean, I'm not saying
I'm sorry. Just
So there are two rules from yesterday, there's one of the legal, the one that's specifically all these things, so we split up like an officer, right? She's not trying to check the price, and I just wanted to,
And so we would want me to be requesting that position.
Okay, so I'll just let you know.
yeah, I know that's something I can actually,
There is no, it doesn't go, no issue.
I understand.
As far as the practice. No, I get it. I get it. Do you believe that this officer has given information about, I guess to me, the person who trespassed?
No, he has.
He was represented to know that. Is there a reason why they need to go and testify? That's what I'm reading. That is how you help the Gotcha. That's fine. It works. Thank you, Judge.
Your Honor, at this point, the state arrest.
Your Honor, at this point, we'd like.
Oh, Jefferson. No, when I. Oh yeah, you can do it.
Yeah, Your Honor, at this time, we want to make a Rule 20 motion. In this matter, as you know, the conviction of trespass in the third degree requires knowingly entering or remaining unlawfully on any real property after reasonable request by law enforcement, owner, any other person having control, prohibiting entry. Now, ARS 1501 provides the definitions for ARS 1502, which is the trespass statute. According to ARS 1501, enter or remain unlawfully means an act of a person who enters or remains on premises when the person's intent for doing so, entering or remaining, is not licensed, authorized, or otherwise privileged, except when entry is to commit theft of merchandise displayed for sale during normal business hours. Part of note is this part right here: when the premises are open to the public and when the person does not enter any unauthorized areas of the premises. Your Honor, today there were 6 witnesses put on the stand. Not one of them could testify that Mr. Ruff was in an unauthorized area. We listened to testimony from Mr. Moreno stating clearly that the first floor, they had no issue with any of the individuals, either of the three, being on the first floor, which they were. According to Mr. Moreno, who has obviously the closest knowledge and of the building and of its regulations, he stated the unauthorized areas were the second floor because of the fact that they have offices and they're safeguarding. As a public policy, it makes sense why those areas would be unauthorized. However, not a single one of the state's witnesses here today can put Mr. Ruff on the second floor, Your Honor. The burden here is on the state, and the burden is not a light one, Your Honor. It's beyond any reasonable doubt, and if we don't have any, not for Rule 20, for this, there needs to be substantial evidence of this offense. We haven't had a single witness here today testify that he was in that area, that they could guarantee, or that they saw with their own eyes that he was in that unauthorized area, Your Honor.
So let me ask you this, Council. Do you believe that he has to be, for my consideration, do you believe that he has to be on the second floor? Do you believe that if he's told to stop and not go up the stairs by security, do you believe that he can ignore that request and continue up the stairs even though he's been advised to stop and there's signage that tells him to stop? Do you believe that he has to get to the second floor?
Your Honor, I believe that there's two issues at hand. First, nobody mentioned to him, neither the signs nor the security guard, that if he continues he'd be trespassed. That's first and foremost. None of the signs that we saw that the state put on indicated that. It said please sign in. None of them were requests. None of them stated that there'd be a trespass violation should you not. There's also one at the very front desk saying do not bypass, but we know for a fact 3 individuals bypassed that. 1 was only charged. The only difference between what Mr. Ruff did and what his, the other individuals he were with did is that he allegedly made it to an unauthorized area, being the second floor. However, nobody here today could put him on the second floor. And the public policy behind that, it doesn't make sense for him being in a stairwell to have those same concerns of safeguarding and protecting the offices and the individuals that are on that floor. None of that becomes relevant unless he's on the second floor, Your Honor. And if we don't have even one person here that can say with their own eyes they saw him on the second floor, I believe a requirement of the trespass has not been met. One of the 2 requirements.
Do you believe if there's no signage that talks about trespass, but a security guard plainly and clearly tells you to stop, but you're not allowed to go up those stairs? Clearly and plainly tells you that. You believe because he doesn't use the word trespass, he doesn't say that he'll be trespassed, or he's committing the trespass.
I don't necessarily think that he has to be specific, Your Honor, that you will be trespassed, but I also don't think that it is clear that the security officer was telling Mr. Ruff that him being on the stairs was an issue. I believe what the security guard was telling him or trying to convey to him is don't go to the second floor. Stop. Don't go to the second floor. While he was on the actual stairs, Your Honor, I don't believe that was a concern. Because again, none of the issues that come and none of the public policy behind the trespass is relevant when he's on a stairwell. And unless we can have a single individual that actually saw him in an unauthorized area, I believe there's a huge hole in the state's case here.
Are there signs going up the stairs that tell him to stop?
Right. So to make an analogy, if somebody is walking up to a yard that says, if you enter on here, that would be trespassing. That's not letting them know that on the way up to that they're trespassing. That's letting them know that area that they are ultimately attempting to get to, in our case, allegedly the second floor, is unauthorized. And again, the law is specific when it comes to a public building as opposed to a private. We've established that this building is public. It is a government public. It's not a private building, Your Honor. So the rule, the stipulation for trespass is different in that it is only in unauthorized areas. And nobody here was able to testify that the stairwell is an unauthorized area. There seems to be no reasoning that a stairwell, none of the concerns that the state indicated are present from him entering the second floor, none of that is present while he's in the stairwell. And the only witnesses we've had out of the 5-6 witnesses that the state put on, not one could definitively put him on the second floor. It's just a substantial piece of the requirement for him being in the unauthorized area, Your Honor, and it's just plainly missing. I mean, if we had even one individual here say, yes, I saw him on the second floor, okay, then that's something. But not one individual here, as you saw, could definitively put him on the second floor, Your Honor.
So, Captain, let me see if I have your argument correct. Your argument, as you just said, if he reached the second floor, that would be unauthorized. But because no one can say he reached the second floor, he wasn't in an unauthorized area. Is that correct? Is that what you're telling me?
Yes, Your Honor.
All right, Mr. Hawkins?
There's signs at the bottom of the staircase for a reason. Okay, so he passed signs that clearly, 2 of them, I mean, the city could not do more. There's 2 pillars that are there just to hold these signs that say stop. Okay, you can't go up here without checking in. There's a security guard posted right there who says, stop, you can't go up there. I mean, what else could city management do to to convey to people that you can't go up there. And again, here we are. The defendant did not care. Okay, this idea that like, well, he didn't really know where he could or couldn't go. No, his response was, this is a public building, I can go where I want. He didn't care about the signage. He didn't care that he couldn't go up there. To carry out defense counsel's analogy, this is the equivalent of somebody having a sign at the edge of their yard saying, stop. Somebody entering in onto their lawn and then claiming, oh, I thought stop meant I couldn't go up to the door. No, you're on the property you can't be on. Once you pass those signs, once a security guard tells you multiple times, hey, you can't go up there, and he still continued up. This idea that there needs to be a reasonable request made. This was more than reasonable. Even if there had been no signage, just the security guard alone saying, he's a person who works here, he's a person with authority, saying, you cannot go up there, you need to come back down. And then you ignore him and you go up, you have trespassed. Signage or no. But there was signage everywhere. There's two right at the bottom of the stairs. He blew right through them. He ignored them. He ignored the security guard. This was a clear trespass. The city has an obligation to protect its employees. And you heard from those employees and how this made them feel, and the way that it made them feel unsafe, and the fact that somebody was somewhere where they shouldn't have been, and the city has a vested interest in protecting them. And they did that. They bent over backwards to do that and to convey that you cannot enter on these stairs, including posting a security guard. The defendant ignored that. He clearly trespassed, and the court should find him guilty. Excuse me, should.
Your Honor, can we just have one? Your Honor, there were signs, as the state indicated, starting at the security desk. We know 3 individuals that bypassed those. The security officer indicated there were signs all on the first floor, allegedly telling people they have to sign in, they have to do this. None of that was abided by all three of these individuals that every witness here indicated. The security guard here indicated that he had no issue at all with them throughout the first floor, signing in or not, passing by, signage or not. That was made clear by the security guard, that the only issue was the second floor being the unauthorized area, Your Honor. So signs or not, they're not abiding by their own signs, or they're enforcing them however they choose to, on some individuals and not on other individuals. And again, the common sense of the law sometimes has to come through. A stairwell is not meant for safekeeping, Your Honor. A stairwell has nothing in it that has a safety concern, Your Honor. And unless somebody can definitively put him in an unauthorized area, the state has not met its burden even to the slightest, Your Honor. I don't understand. It's a lot of speculation. He could have made it to the second. He could have did this. We don't have one individual that actually puts him there. And these signs that they're saying are so important, apparently everybody else bypassed those, at least the individuals he were with, and according to the security guard, there was no issue with that. The only issue came when Mr. Ruff allegedly went to the second floor, which the state cannot prove.
My understanding of the signing purposes, if you have business there, you want to go up to those offices or go into an office or have a meeting with somebody, they want you to sign in. And in this case, the officer didn't say anything to Mr. Ruff nor the other 2 individuals. He allowed all 3 of them to be on the first floor. That was his testimony. And it was only when I believe that Mr. Ruff started to go up the stairs, he told him specifically that he couldn't do that. So he was, not only were there signs, but you have a security officer who's telling you to stop. You can't go there. And based upon that reason, the court's going to deny the request for a guilty.
Your Honor, once again, I have discussed with Mr. Ruff his right to testify. I've laid out that it's his absolute right to do so, that it can't be used against him if he chooses not to. Mr. Ruff has indicated to me that he does not wish to testify in this case.
Does the defense have then anything to present?
No, Your Honor, no witnesses for defense.
Thank you, Your Honor. Judge, I don't have a ton to add to what's already been said in Rule 20, other than the city has a vested interest in protecting certain areas of its buildings. There's certain areas where employees work. Other parts of that building are open to the public, but some are not. And the city, again, completely went overboard to convey what needs to happen and what areas you can go into and what you cannot go into. To the extent of posting signs on each side of a stairwell or stairway, and posting a security guard right there. Defendant wandered around a little bit, asked some questions of Ms. Fantasia, and then made the choice to go up the stairwell. According to the security guard's testimony, he recorded the signage before going up the stairs. Again, he's intentionally encroaching on areas that he knows have been prohibited. He just simply believes that they shouldn't be, or that it shouldn't apply to him. The security guard tells him, hey, you can't go up there. This is a public building, I can go where I want. I know better than you do. I can go where I want. The security guard continues to try to stop him. He refuses. He continues up the stairs. The security guard calls law enforcement, who eventually shows up. You heard from the individuals who were working on the second floor and how bizarre it was to see that happen. That's evidence that the vast majority of people who walk into that building know that they can't go up those stairs because it never happens. The two other individuals that were with the defendant clearly understood they can't go up those stairs. They never did it. The individuals who worked there testified that nobody goes up those stairs without an appointment. The individuals who are in that building, the signage, the security guard, it's all sufficient to convey to people where they can be and where they can't be. He chose to ignore the security guard, chose to ignore the clear signage. He trespassed on city property. The state asked you to find him guilty.
Yes, Your Honor. Without rehashing everything that we mentioned in the Rule 20, which was the crux of it, obviously at this point it's a much higher burden on the state in terms of proving this beyond any reasonable doubt at all, Your Honor. And I would just point to the fact that, again, we don't have a single individual here that could testify that Mr. Ruff went on to the unauthorized second floor, Your Honor. Again, it's a glaring element that's completely missing from the state's case. Whether or not the stairs are a protected area has not been proven at all. All we know is that the purpose of having an unauthorized area was to safeguard offices. There are no offices in this stairwell. If the officer specifically wanted him to leave the stairs for whatever reason, he could have been specific as to that. Anyone that is told stop while going up the stairs, it is a natural thought that they mean not to enter, obviously, the second floor. There's nothing where he would have been standing that was to be protected. It's a stairwell, Your Honor. Just a common sense reading of these issues it's clear that unless we even have one person putting him in a definitively unauthorized space, Your Honor, the state can't meet its burden. And again, obviously we're not talking about a Rule 20 burden here. Now we're talking about beyond any reasonable doubt, Your Honor. And for that reason, we would ask for a finding of not guilty. Thank you, Your Honor.
Haven't heard the testimony, specifically that of the security officer, as well as Ms. Fantasia, was clear that the defendant was instructed to stop. Clearly he was told not to go any further. He was told not to go any further by the security officer in charge of that area. Mr. Ruff, for whatever reason, turned around and said, "This is a public building, I can go wherever I want," even though he was specifically told by someone in authority not to go any further. I don't know what the end game was, but for that reason, the court finds that the state has met its burden and finds the defendant guilty. We have another one at 1:30.
Correct, Your Honor.
Judge, I'm sorry, I have Exhibit 6 here. The state moved to admit it didn't get moved. May the state be excused until
Yes.
1:30 this meeting?
Yes.
Defense as well, Judge.
Yes.
Thank you.
Thanks for getting open.
We'll waive, Your Honor.
Mr. Hawkins, you want to go ahead and call your first witness?
Thank you, Judge. The state calls Officer Salas.
Raise your right hand. Do you swear from the testimony that you are about to provide in this court that you will truth and nothing but the truth?
I do.
Go ahead, sir, you got a seat. Whenever you're ready, Mr. Hawkins.
Thank you, Ron. Officer Salas, where do you work?
Mesa Police Department.
How long have you worked there?
A little over 15 years.
Is Is that where you were working back on March 13th, 2021?
Yes.
What was your assigned duty at that time?
I was assigned to patrol as an FTO, which is a field training officer.
What is a field training officer?
We get new recruits that go to the academy, and we walk them through the field training. So we basically have them for several weeks to train them on the job, basically. And observe them.
Back on March 13th, 2021, were you actively training a new recruit?
Yes.
Is that more difficult than normal police work?
Yes.
Why is that?
Well, first you got more responsibility because you got to be concerned for the OIT themselves. Because they're brand new, they're not a seasoned officer, they don't have all the experience as a regular officer to have. So you got to be able to teach them, guide them, and then observe their actions, and make sure yourself and your training is safe.
So in some ways, does it just give you one more thing you've got to observe?
Yes.
On March 13th, 2021, at around 9 o'clock in the morning, did you come into contact with an individual who eventually became known to you as Christopher Rudd?
Yes.
Do you see him here in the courtroom? If so, would you just point him out and describe him to the judge?
It's a person in the gray shirt, the long sleeve underneath.
Your Honor, would the record reflect that the officer has identified the defendant?
Correct, or self-reflect.
What were you doing at the time that you first encountered Mr. Rudd?
The OIT and I just initiated a traffic stop on the vehicle, and I was at the passenger side of the vehicle.
So when you say you initiated a traffic stop, were you guys in a separate vehicle and you observed the vehicle commit what you believe to be an infraction?
So when you have a training with you, they're always with you in the same vehicle until the end of the training period. That was the beginning of the training period. So if we're in one vehicle, at the time, the trainee was like being pursued.
Do you recall what area of the city this happened in?
It was between Greenfield and Bell Vista on Main Street.
Is that in the city of Mesa?
Yes.
So when you make this traffic stop, where does the car pull over at?
It varies. In this particular case, we pulled over to a curb lane next to the sidewalk.
So the vehicle didn't pull off of the roadway into like a parking lot or anything like that. Is that right? If I understand you correctly, the vehicle simply pulled over into kind of the bike lane next to the sidewalk?
Yes.
Does that mean that the vehicle and your vehicle are both still in traffic?
Yes.
Does that increase the danger to you and to the person you pulled over as opposed to if they pulled off into a parking lot?
Well, it only added issue with being on the roadway, still you got to worry about traffic going behind you. And you also got to worry about sidewalk and all that stuff. The added thing is traffic on the roadway.
Would it be safe to say that when a traffic stop is conducted in that manner, where they just pull over, well, let me ask you this, are they still, when someone just pulls over the curb like that, they're still blocking the lane of traffic, are they not?
Yes.
So in that regard, that kind of a traffic stop still impacts the traffic around it, correct?
Yes.
Okay, so you guys make this traffic stop. At what point do you encounter the defendant?
But just a few minutes after we contacted the driver, I was on the passenger side. I can't give you the exact time, but it was a few minutes after we initiated the stop.
I'm sorry, can I just ask, I really said it, but I just didn't know. What was the location again?
It was on Main Street between Greenfield and Bell Vista.
Thank you.
And on that point, let me just clarify, are you guys on Main Street facing westbound or eastbound?
Westbound.
Okay, so at the time that you encountered the defendant, were you and your OIT still interacting with the traffic stop itself, the driver of the other car?
Yes.
Were you wearing Axon video on the day in question?
Yes.
Okay. Is this an accurate representation of the traffic stop that you were involved with at the time?
Yes.
Now, on the left-hand side of the screen, you can see someone else wearing a blue cap and a mask. Who is that?
That's my training.
Okay, that's your trainee. This is the person you're training how to be a police officer.
Yes.
Okay, I'm gonna go ahead and play this. Is this your Axon video from the incident?
It looks good.
The individual walking towards you, do you recognize that individual?
Yes.
And who's that?
This is right.
Hey, how you doing? Not too bad. Hey, can you keep walking? You can film. Just keep walking over there.
What's your name, badge number, field training officer?
Go over there. We'll deal with that later. You need to move.
This is public sidewalk, guy.
You need to move.
Public
Seriously.
sidewalk.
You need to move. You need to go back. I'm dealing with this. You're now interfering with our investigation. You can go over there.
Interfering is a physical act.
You need to go. Go.
No, you know what? Fuck you.
Dude, if you don't leave to that part over there, I'm dealing with the investigation.
Find your supervisor.
I'm doing an investigation right here. If you don't move back over there, so I can deal with this investigation,
Mesa PD.
if you don't move, you're gonna get arrested.
Badge number, nothing.
You need to move back.
Body cam on.
You need to move back.
I'm on a public sidewalk.
You need to move back. We're dealing with that. Hey, watch your driver. You need to move back.
Who do you think? I'm on a
You
public
need
sidewalk.
to move back.
You want to put a tape or something?
Are you gonna move back or no?
No. I'm on a
Okay.
public sidewalk.
You need to move back.
I'm on a public
You need to
sidewalk.
move back.
Try to check yourself, homie.
You need to move back. You're interfering with my investigation right now. One more warning. One more warning. You need to back off.
Go ahead, dude. 10 foot.
You need to back
10
off.
foot, you stupid fuck.
You need to back off. Okay, you know what?
Dude, don't touch me. Don't touch me. I'm on a public sidewalk. Stop.
Stop right now.
Dude, you're fucking up.
Okay, yep.
You're fucking up.
Okay. At that point, do you place the defendant under arrest?
We detain this.
Okay. Why did you arrest him?
Failing to back off, and I instructed you several times.
Did you feel that you were giving the defendant a lawful order?
Yes.
I'm going to run back through some of this just to illustrate a few things and ask you a couple questions.
Hey.
Hey, how you doing?
Okay, so at this point, it seems that the interaction starts off fairly friendly. Is that accurate?
It was cordial.
He says, howdy, how you doing? You respond.
Not too bad. Hey, can you keep walking? You can film. Just keep walking over there.
What's your name, badge number, field training officer?
Go over there.
What's your name, badge?
We'll deal with that later. You need to move.
This is public sidewalk.
So with where he's standing at right now, I'll try to...
You need to move.
With where he's standing now, why is that a problem for you?
Well, there's a lot of safety issues just with that, and I don't know that person's intent with, I don't know if he's associated with the driver. He's also posting a safety issue for myself and the driver if he's not associated with the driver, and also my training.
Okay, at the time this happened, back in March of 2021, did you know the defendant?
No.
To your knowledge, at least, you didn't have any idea who this individual was?
No.
Did you know what his intentions were?
No.
Did you know what his intentions were with regard to the driver you had pulled over?
No.
Does having somebody that close to you and that close to the individual you've pulled over present safety issues for you as a police officer?
Yes, it does.
Does it present potential safety issues for the individual who you pulled over?
Yes.
Does having an individual that close to you cause you to have your attention diverted from the task at hand, which is the individual that you pulled over?
Yes.
Where did you want him to go? Because I know you said you can still keep recording, I just need you to go over there. Where did you want him to go?
I want him to go past our control vehicle.
Okay. Which, if you had to estimate the distance, how far was it?
30 feet maybe, I guess. I would have a good guess.
How far from you is he standing right now?
He was pretty close to me.
Seriously, you need to move. You need to go back. I'm dealing with this. You're now interfering with our investigation. You can go over there.
Interfering is a physical activity.
Okay, so at this point now, you have said you can go over there. Is that different than the initial place you had told him to go?
Yeah, because initially I told him you can keep walking and go back or go over there. I pointed towards the end of the shoulder there. And then as he adjusted himself, I told him you can go over there, which is pointing towards the front of the other car, or beyond the other car.
So, to be clear, do you really care? Do you care more about where he goes as far as which side, or just as far as him being a certain distance from you and the individual you pulled over?
Yeah, I just wanted to get a safe distance for myself and lifestyle.
You need to go.
No, you know what? Fuck.
Dude, if you don't leave to that part over there, I'm dealing with the investigation.
Call your supervisor.
I'm doing an investigation right here. If you don't move back over there, so I can deal with this investigation,
Mesa PD.
if you don't move, you're gonna get arrested.
That's number nothing.
You need to move back.
Body cam on.
You need to move back.
I'm on a public sidewalk.
You need to move back. We're dealing with that. Hey, watch your driver. You need to move back.
Now, at this point, you have an interaction with your officer in training. And you address your officer in training just briefly. What was the issue with what he was doing?
Because he was focused on rough, and then we still have to deal with, there's so many unknowns with the car still. That's why I told him to watch the driver and make sure, for safety reasons, to keep an eye on the driver.
Was he losing his focus on the driver?
Well, I just noticed that he was paying attention to rough, and that's why I instructed him to watch the driver. That's why it's so hard when you're dealing with this. You gotta watch the OIT, make sure he's doing what he's supposed to, and make sure everything stays safe.
So at this point, are you trying to watch the driver, the OIT, and the defendant?
Yes.
And to be clear, at this point when this happens, you don't know what the defendant's intentions are, correct?
No.
You don't know what the driver's intentions are, correct?
I'm on
You need to move back.
You want to put a tape or something?
Are you gonna move back or no?
No. I'm on
Okay.
Okay, so at this point, it appears from the video the defendant is essentially standing right on the sidewalk, directly parallel to the passenger side window of the vehicle. Is that accurate?
Yes.
And you just flat ask him, are you going to move? What is his response?
No.
So given that he's not going to move, in order for you to have any interaction with that driver through the passenger window, would you effectively have to turn your back to this individual who's now standing there and refusing to move?
Yes.
Does that present a problem for you?
Oh yeah.
I'm on a
Okay.
public sidewalk.
You need to move back.
I'm on a public
You need to
sidewalk.
move
You
back.
better check yourself, homie.
You need to move back. You're interfering with my investigation right now. One more warning. One more warning. You need to back off.
Go ahead, dude. 10 foot.
You need to back off.
10 foot, you stupid fuck.
You need to back off. Okay, you know what?
Dude, don't touch me. Don't touch me. I'm on a public sidewalk. Stop.
Stop right now.
Dude, you're fucking up.
Okay, yep.
You're fucking up.
Did you have a problem with the defendant recording that video?
Oh no.
What was your issue?
He just remained next to us and he went and moved further back.
Had he moved a little further, either direction, would you have had any interaction with the defendant that day?
No, besides giving my badge number, we're all done. Other than that, you could have stood back from the front of the car or by the patrol car and gone.
Stays no further questions, Judge.
I know there wasn't any objection, is that state's one?
It is. Sorry, Judge. And the state would move to admit state's one into evidence.
No objection, Your Honor. Officer Salas, what time of day was this stop?
Morning time?
Okay, it was light out, right?
Yes.
Okay. What was the nature of the stop on the vehicle? It was a traffic stop, you stated?
Yes.
Correct. And if I recall from your report, there was no registration or something of that nature. It was a low-risk stop. Is that fair to say?
Well, no, every stop is a high risk until it's not.
So every stop that you have a traffic stop and an individual's walking by a sidewalk, you're not going to allow that to happen because it could interfere with the potential vehicle that you're stopping? Is that what you're saying?
Yeah, so if you're, we'll take this scenario, if you're here and someone's walking by, that's why I was observing them pass by and then you stop. So generally people, even people that film, they walk by, they say whatever they say and they keep walking. So that's why you walk, like if people would have kept walking, I would just watch, make sure you went to a safe distance and we would continue on with the traffic stop. So every traffic stop is a high stop until it's not, because you don't know until it's over.
And you stated that you had a partner there with you that day or an officer in training, is that correct?
Yes.
Would you agree that having two officers on a single person stop is safer than having one?
Two full-fledged officers.
So Officer Blake graduated from the academy, correct?
Yes.
Officer Blake was in phase 3 of his OIT training, 3 out of 4 levels total, correct?
If I remember, it was first phase.
Okay, maybe we'll have him testify to that if he's testifying. Is it possible you could have told the driver to move to a different spot if you had any concerns of safety?
I don't understand.
You could have had the car not stop in the middle of the street, is that fair? Or on the street, or to a parking, any other area that may have allowed you to be better protected in your mind?
Generally, you don't have, as soon as you initiate the stop, you contact the driver, you don't have them move different locations. That opens up a whole lot of new issues.
But could you have, hypothetically, theoretically?
I've never done that.
For officer safety. I haven't asked you if you've ever done that. Could you have done that?
I don't see a time when I would. If I'm conducting an investigation, I don't know if I would ever have a driver just move out of the road for us. Unless it was the end of it and I knew, what we were going to do or what have you. But in that situation, I can't see. It's not practical.
You testified that it was a more dangerous situation specifically because of where the vehicle was parked, correct?
No, I said it added extra because you have to worry about traffic.
So that's what I just said. Is that not what I just said? So there wasn't any safeguard that you could have done to alleviate those concerns. This is all prior to Mr. Ruff even arriving on the scene. You mentioned that naturally having a stop where this stop adds an extra layer, if you will, that you have to worry about, correct? So you could have alleviated those concerns by having the vehicle move, correct?
No, because you add extra concerns at that point. If you have the driver move off the road, you add extra issues onto your traffic stop, so it's not practical.
What issues would those be?
Could be a number of things. The driver could decide, I'm taking off and just leave. Gives the driver opportunity to gain a weapon that they originally couldn't get a hold of before we walked up. You open yourself up to a lot of unknowns at that point.
But just to be clear, the nature of the stop, you didn't stop this vehicle because it was a stolen vehicle or it was suspected to be a dangerous criminal's vehicle. The reason you stopped it was a traffic citation, correct?
We didn't know what it was.
What was the reason you pulled the vehicle over?
For speeding.
Okay, so traffic citation.
It's traffic violation.
Violation, correct? You said you've now been an officer for, was it 30 years you stated? No.
I'm 13? Not that old.
Sorry, 13?
15.
15, okay. So in your time as an officer, how many cases have you investigated? Ballpark.
Hundreds.
Okay. More than 500? Somewhere around there?
I don't want to give a number,
Okay. So in any of your investigations out of these 13 to 15 years, do you regularly have a suspect videotaping themselves actively committing what you think is a crime? You did know that he was videotaping, correct? You acknowledge that?
I assume, yeah.
And your concern was officer safety, correct?
Yes.
So then that he might engage in criminal conduct, correct? That was your concern?
No, it was safety for myself, my other officer, and the driver. And I know his association with the vehicle.
So you don't believe that him recording himself and recording this interaction would have any effect on him committing a crime while he's recording it?
I see people do some crazy things. I have no idea. I can't testify to what he's thinking.
Now, you stated that you would have felt more comfortable with him about 30 feet away, correct?
Yeah.
And yet you also stated that that he was welcome to record this interaction, correct? So from 30 feet away, would he be able to actually record the interaction or any of the words spoken that you spoke to either the driver or your other officer, or pick
no
up
idea what type
anything of substance?
I have no idea what type of equipment he has, or good car and bad phone, or whatever.
And if you told him to get behind the squad car, would that not obstruct his view?
No, I don't think so.
You don't think so? Now, you did state that you didn't know what his intentions were, and that was part of your concern, correct?
Yes.
But you did acknowledge that he was recording, correct?
Yeah.
So you knew his intent was to record this interaction, correct?
I don't know. I don't know if he had other ulterior motives besides recording. I don't know.
Now, is it Mesa police policy to identify when asked, either with your badge number or name?
They're required to give either your name or your badge.
You didn't give either, did you?
At that particular time when I was interacting with him, no. I told him we'd take care of it afterwards.
So you didn't, correct?
At that particular time, no.
When asked, you did not.
I give it to him later.
Okay. So an officer in training is allowed to carry a firearm, correct?
Yes.
They're allowed to respond to scenes along with you, correct?
Yes.
It goes to the safety issue directly to. If you have an officer in training that you're training currently at a stop with you, and you receive an emergency call, that officer would respond with you, that officer in training, correct?
Yes.
I have nothing further, Your Honor, for this.
At the time you were asked for your name and badge number, did you have other things that were more pressing concerns to you?
Yes, not knowing his intentions, still dealing with the driver, and having to watch my OIT, I just told him we'd take care of it later. I planned to, after we finished the trial stop, if he was still on scene, I would just go do my badge number and do it all done.
But at that point, your main concern was the safety of everyone involved?
Yes.
I don't even know if you're a judge.
So you can start there.
Thank you.
You want to state rest?
Your Honor, at this point, we would move for a Rule 20. In this matter, actually, we believe the state actually failed to charge Mr. Ruff with the appropriate statute. The state charged Mr. Ruff with the transportation and operation of motor vehicles statute, Article 28 or Title 28, which involves motor vehicles and transportation, Your Honor. The statute itself states 2862A, a person shall not willfully fail or refuse to comply with any lawful order or direction of a police officer invested by law with authority to direct, control, or regulate traffic. Now, when we look to 28621, which defines 28622, it states explicitly, the provisions of this chapter and Chapter 5 of this title relating to the operation of vehicles refer exclusively to the operation of vehicles on highways except 1, if a different place is specifically provided by statute, and 2, Article 4 of this chapter and Section 28693 apply on highways and elsewhere throughout the state. Accordingly, the state failed to meet its burden by charging the wrong statute, Your Honor. If they chose to charge with interfering with judicial proceedings, that would have been applicable in this matter. Again, Section 28 does not deal at all with non-motor vehicle violations, Your Honor.
Counsel, can you look to 2860, 28 traffic? traffic means pedestrian, ridden or herded animals, vehicles, and other conveyances either singly or together while using the highway for purposes of travel.
No, that was not the highway, respectfully. It was clearly a sidewalk.
No, I understand that he was on the sidewalk, I understand that. So, but I'm just saying, I think 28601, 28 specifically talks about what traffic is, and it talks about the traffic can pertain to pedestrians as well, not just one vehicle. Do you agree?
I would agree in the limited instances where it applies to pedestrians within a highway setting. Aside from that, it's clear from the record this was not that setting.
And that's something that I already looked at before you reached your opinion, so that was going to be my question. So my question then, I'm going to turn this over to you, Mr. Hawkins, is it's clear that he failed to obey a police officer's directive. It's clear that he was on the sidewalk. It's also clear in my mind that a police officer can direct a pedestrian, but does that mean that the person has to be using a highway for purposes of travel? I guess that's what I'm looking at. That was my question, actually. That was my question as this unfolded and started. I didn't know. I think it would be different if Mr. Ruff were on the street and he was advised to get off the street for whatever reason. But the fact that he's on the sidewalk, do you believe that this statute still applies?
Yeah, I absolutely do, Judge. And we looked at this pretty hard before this was ever charged. And it applies for multiple reasons, not the least of which is this is still all tied to a traffic stop. There are still two vehicles that are blocking traffic. They are actively obstructing traffic. It involves other traffic. Other traffic's having to go around these vehicles, and all of that is being prolonged because of the defendant's behavior. So the statute says, someone willfully fails or refuses to comply with a lawful order or direction of a police officer invested by law with authority to direct, control, and regulate traffic. They are trying to direct, control, and regulate traffic. They observed a traffic violation, or believed one, conducted a traffic stop. That traffic stop is still implicating other traffic. It's in the roadway. And the defendant, by his actions, caused that to be prolonged for a much longer time, had a much bigger impact on surrounding traffic, and it absolutely fits under the statute. The other thing I would add is there is a case, and sorry, I was having some technical difficulties, but there is a case regarding this statute. It's Owner v. Mitchell. It states Arizona law also criminalizes the failure to comply with a police officer's lawful order as a class 2 misdemeanor, carrying it to 4 months in jail. It quotes State v. Gonzalez, which says a person shall not willfully fail or refuse to comply with any lawful order or direction of a police officer invested by law with authority to direct, control, or regulate traffic. The Arizona Court of Appeals and State v. Gonzalez determined that the misdemeanor offense of failure to obey a police officer, pursuant to ARS 28622, quote, requires proof that one, a person willfully failed or refused to comply with any lawful order or direction of a police officer invested by law with authority to direct, control, or regulate traffic. And this is kind of the conclusion that I'm getting at. The court ruled, thus, ARS 28622A is not limited to police orders related to controlling or regulating vehicular traffic. Plaintiff does not challenge whether Officer Mitchell had such authority. So it's not just limited to actual, are you controlling cars? Okay, because obviously pedestrian behavior, other behavior like that, does implicate vehicles and things of that nature in traffic.
Can you give me that case citation?
Sure. State v. Gonzalez is 221 ARIS 82.
I'm sorry?
It's 221 Arizona 82, or Aries A.
Gotcha.
RZ 82.
Okay. Let me just do this. Let me go back. I just want to. Did you have anything further to add? I wanted to just go at it briefly.
Your Honor, the only thing we have to add is clearly, even just from a brief reading of this matter, the plaintiff, or the Mr. Gonzalez in this matter that the state is stating to was not on a sidewalk. Again, 60621 explicitly defines what 622 applies for. Very rarely do you have a statute say this exclusively applies to the operation of vehicles on highways, except in these limited instances. I mean, it's clear as day. I don't know how much more of a plain reading of that statute we'd need. There's no ambiguity with this statute at all.
Would you also agree that there's no ambiguity with the definition of traffic?
Even the statute itself, Judge, it doesn't say
Right.
the police officer must be regulating traffic. I mean, if we're going by the strict letter of the law, it says a police officer invested by law with authority to direct traffic.
I'm pointing to 621. 621 is explicit in the provisions of this chapter and Chapter 5 relating to the operation refer exclusively to the operation of vehicles on highways except, and it has two very narrow exceptions. And Gonzalez is a traffic stop, Your Honor. In this case, Mr. Ruff had nothing to do with this vehicle that was stopped. There's no correlation at all with Mr. Ruff and whatever vehicle was stopped here. It's not like the State v. Gonzalez case, where Gonzalez in that case was the driver of the vehicle.
Let me just. Let me take. I haven't read Gonzalez.
Yeah.
So let me just jump off the bench and pull it up. I just want to read through it because I have it back. Okay.
Sure.
So, Mr. Hopkins, I heard what you said when you were referencing Gonzalez, and so I read through it carefully, but was there a specific area? Because I thought you had read that there was some language in Gonzalez that said it just doesn't have to be.
Yeah, Judge, and you know what, I mistakenly passed on you the wrong citation. Actually, what I was reading from was State v. Boner v. Mitchell, which is a district court case, which was quoting Gonzalez, and then after quoting Gonzalez, they came to that final conclusion that I passed on to you. They said, thus, ARS 28622A is not limited to police orders related to controlling the river and vehicular traffic. But after you left, I realized I passed on Gonzalez in the citation and not the citation for Boner v. Mitchell, which is a district court case that, like I said, quotes Gonzalez and then comes to its conclusion. But Judge, for what it's worth, I do think this issue is solved when we dig into the definitions of street, highway, roadway, and sidewalk. 28101 defines street or highway, and it says that means the entire width between the boundary lines in every way. Sorry.
28101.
Right.
I think I've given you this before. It's been a while, so just give me a second.
Sure.
Under what subtitle is it?
And I believe it's 52. It's under the definitions, but I think it's number 52.
52. That's how the English statute.
Well, you know, check 76. It might be 76, Judge.
Judge, that
Your
literally
Honor,
says for
state
purpose of vehicular travel,
in the definition,
which is the opposite of a sidewalk.
And I'm not done yet, Judge.
I'm sorry.
That's part of it.
I'm not finding the definition.
It's on 76.
It's under 76.
Hang on, just stand it up. Mine says truck tractor for 76.
28601. It's
Oh, you're on
definition.
28601. I think you said.
Sorry, Judge.
I can't hear you. I think you said 28101.
I did, sir.
It is 28101.
It's 28101, but it's number 76 and 28101.
I have. What year is this? pull it up on my computer.
Right, depending on what age book you grab. I've got one.
This is.
I've got one from 2018-19.
I have it. This is street or highway means the entire width between the boundary lines of every way. Part of the way is open to use for the public for the purposes of vehicular travel.
Right, so street or highway means the entire width between the boundary lines of every way if a part of the way is open to the use of the public for purposes of vehicular travel. Now you combine that definition with the definition of sidewalk, which is in 28601, and it says sidewalk means that portion of a street. Okay, so sidewalk is a portion of a street. Sidewalk means that portion of a street that is between the curb lines or lateral lines of a roadway and the adjacent property lines. So sidewalk is between the curb lines of a roadway, okay, the outside lines of the roadway and the property lines that's intended for the use of pedestrians. Okay? So it is part of the street by statutory definition. Now it's the part for pedestrian travel. It's not the part that is for vehicular travel, but it is considered statutorily part of the street, which is why street or highway means the entire width between the boundary lines of every way if a part of the way is open to the use of the public for purposes of vehicular travel.
Do you read it that way?
No, Judge. And again, I think another key is the provision says that the applicability of this section is strictly for certain purposes. I don't believe there's any evidence that this event took place within those parameters we're moving for a Rule 20 directed verdict.
So let me ask you both this. So here's my thought process. Let's assume that it deals with traffic, okay? If the police are investigating a traffic issue, dealing with somebody who obviously falls within our parameters or the definition, means the person that they pull over, and they're trying to give another person a directive so they can continue to investigate the traffic infraction, would that not apply?
The reason we would maintain it doesn't, Judge, is he is not involved in the traffic infraction in any capacity. The infraction, the applicability of Section 28 is for the infracting party. His infraction is failure to comply. Okay, but again, he is not within the parameters for which that statute is written. And again, at this point as well, the car has been pulled over, it's stopped. Okay, so I don't believe that his involvement is part and parcel to the traffic infraction. The fact that he's on site, again, I think this could be applicable if he was in the middle of the road, presenting a risk to himself or others, preventing traffic from traveling. I think that would clearly fall within the statute. But again, I think that there are criminal statutes that could very easily apply to a pedestrian walking on a sidewalk, and I think they've opted for this one. But again, it falls under a traffic citation, 28-621. The provisions of this chapter and relating to the operations of vehicles refer exclusively to the operation of vehicles on highways. Exclusively. And
I agree with that, but this vehicle is, and we know what the definition of highway is.
Correct.
Together, but I guess where I'm looking at this, and I wish I had some case law to help me, but where I'm looking at this is exactly what they're dealing with. They're dealing with a traffic issue. They're dealing with a vehicle, and they're trying to investigate that issue, whatever it may have been, and they're giving another individual a directive or an order so they can do that.
I would maintain it is not relating to, which is the language in the statute, their contact with Mr. Ruff is not relating to the traffic infraction that is taking place. He made a point that it is an officer safety issue that he's referring to. That's not dependent on the fact that this is a traffic stop. Their entire case is predicated on the fact that he believes he can give a lawful order if he believes officer safety is at risk. This isn't to do with somebody interfering with the traffic stop. Okay, this is an officer safety issue, and again, they're using a statute that is clearly excluded by 28/6/21.
Well, I'm going to agree with you to a point that, but it is interfering with their investigation of the traffic stop because they had to delay or stop what they were doing. So it is interfering with it. But my issue then becomes not that. That's clear to me. But my bigger issue or my question is because Mr. Ruff is not on the street. That's what my issue is. He clearly failed to obey by what the officer was telling me. My issue is because he wasn't on the street, because he himself wasn't on the street, because he wasn't given a directive while he was on the street that can deal with a pedestrian as well. Does this statute still apply? That's how I'm looking at this. And I'm not saying that that's correct, but that's what I was thinking.
Judge, if someone were standing on the sidewalk and holding a pole out into the street, would an officer be able to give them a lawful order to, hey, you can't put that pole out there. A car is going to hit that pole. If they're standing on the sidewalk, but it clearly implicates traffic. Clearly, an officer, in order to do their job, and this contemplates that, has to be able to give orders to people who are on the sidewalk who are implicating traffic. And that's what this is. He clearly implicates traffic. They are parked in the roadway, at least partially. They're affecting traffic clearly. You have an individual who, by his behavior, is impacting that traffic. He's prolonging that investigation way longer than it needs to be. They're blocking traffic way longer than they need to be. It's no different than an individual who's holding a pole out in traffic but standing on the sidewalk. Under the reading that they're asserting, the officer cannot tell that person, hey, you can't stick that pole out there. That's not a lawful order. They have to let that go. That doesn't regulate traffic. It doesn't impact traffic.
Respectfully, Your Honor, we're not saying that we're saying that they charged the wrong statute. There may be another applicable statute should the individual be in this example that Mr. Hawkins gave. We're simply saying they charged this wrong. This title has to do with transportation and motor vehicles. I mean, just a plain reading of the statute and of the facts here, a common sense reading, is that this is not he was not charged with Title 13. Any criminal actions is a transportation motor vehicle statute. The purpose of that is abundantly clear in the definition section immediately preceding. And the case that the state implicated, State v. Gonzalez, only reaffirms our point, Your Honor, in that Gonzalez, in that matter, was a driver of a motor vehicle. It was a operation of a motor vehicle incident. This clearly is not. This is very different.
And Your Honor, there is case law, and again, we're getting into this case law battle here, but Houston v. Hill, there's case law that citizens can engage with police officers while they're in the course of their duties. It does not de facto trigger a right for them to obey any order that is given. So there is case law that people are allowed to record officers doing their job. People are allowed to engage with the officers who are doing their job. The officer here is asserting that it became an issue regarding his safety. But again, none of that negates the fact that Mr. Ruff was exercising his rights on the sidewalk and has been charged with a traffic infraction. At the end of the day, that's what we're dealing with. There are ways this could have been handled differently by the state, but a man who was on the sidewalk exercising his rights was charged with a traffic citation that does not apply pursuant to the statute.
All right, well, I hear what you're saying, Counsel, but there isn't anything in Title 13 that I can think of.
Interfering with judicial proceedings or some of the other charges that he has in terms of interfering with an active investigation. Anything that is not a motor vehicle or traffic violation, Your Honor, it doesn't apply.
Just because we can charge somebody with something else doesn't mean they must. Again, to act like a pedestrian who's interfering with a traffic investigation that's blocking traffic doesn't implicate traffic is simply absurd. This is a lawful order given by an officer who is empowered to regulate traffic, and he's involved in a traffic stop that is blocking the roadway. How could this not be contemplated by the statute?
Your Honor, I would point to the state's own citing of State v. Gonzalez.
Interfering with judicial proceedings, I just didn't think that applied. It doesn't.
Judge, let me go to Gonzalez real quick. Gonzalez requires proof of 5 things. It explicitly says it requires proof of 5 things. One,
where are you at? Where are you at with Gonzalez? I have it printed. Just tell me what keynote are you on?
Yeah, I don't have that here. So
what paragraph?
It starts, Arizona law also criminalizes, it starts with,
You want to come in here and point it out to me on mine, because I have to print it out. That's to join me and Kim, so I know you're doing it fine. Is that a court? Is that something I can pull up?
Like, you know, like you did.
Yeah, let me see it. Where's that at? Where's
The relevant portion of it's quoted in the law.
That's just talking. Oh, it's not a reported case.
Doesn't really consider it, right?
Let's see. We also have Supreme Court case law, we have that too. Okay.
The only point I'm making is that Gonzalez says you need 5 things on the 28-622. You need a person, number 2, who willfully, and number 3, fails or refuses to comply with, number 4, any lawful order or direction, number 5, other police officer who's invested by law with authority to direct, control, or regulate traffic. We have that. All 5 of this. This officer is invested with authority to regulate traffic. He gave a lawful order. The defendant failed to comply with it. The elements are met.
I agree with you that some of the statutes, why would, and I wish the statute was more clear, but why would the legislature, and we're talking about legislative intent and stuff like this, if it were intended to be of just disobeying a police officer, right? Because that's what we're talking about, whether it be for a traffic violation or for directing traffic, whatever it is. Why wouldn't that fall under the ambit of Title 13 as opposed to Title 28?
Why didn't they pass that?
No, what I'm saying is, why is the statute specifically under Title 28? Why would there be a Title 13 statute? Why wouldn't this, if it wasn't meant for traffic, right? Because you would think, and there isn't, I'm surprised there is no failure to obey under Title 13. We just don't have it. Why, I don't know. But wouldn't this lend itself to, again, I hear what you're saying, but it just begs the question, why would this be under Title 28, at least for me?
Right. And I understand that, Judge, and I think the courts understand that too, which is why I think Gonzalez does go on to say, look, it's these 5 things. I really do think Gonzalez stands for the proposition of it doesn't have to apply to traffic. If you have an officer who is invested with by law with the authority to direct, control, regulate traffic, that is enough. And I think Gonzalez is recognizing that.
Right.
Your Honor, there's a big distinction in Gonzalez, respectfully.
So no, I understand. So let me tell you what I want to do. I mean, you guys can. You've rested. You've moved. Obviously, this is going to be the. Are you all going to present any evidence on this?
Further? No, Your Honor.
I don't really need to. So you all rest. I don't really need to hear closing argument because this is the issue for me. Even though this is not a published opinion, right? It's my understanding.
That's a Supreme Court opinion case.
But you just gave
That's what I just gave you.
Oh, I apologize, Counsel.
Correct.
What case that was?
That's Houston versus Hill, City of Houston v. Hill. I have a copy for you as well if you'd like. And Your Honor, if you just skip through to the second or third page, there's some relevant highlighted portions.
Largely has to do with, Your Honor, the assertion that he's interfering with the officer's ability to do the stop. Houston v. Hill is on point to the issue that, the degree of interaction and potentially even harassment of police officers doesn't rise to the level that it's necessarily interfering. So it's sort of more in rebuttal to the fact that the assertion is, to the case in general. I know you said you don't need closing arguments. We were going to raise that issue about Mr. Ruff does have rights that are being limited by an officer telling him to back off. So the question then becomes, is it a reasonable order that he is hindering those rights of him? We maintain that there wasn't a sufficient situation here for officer safety to reach that level. But then it also becomes relevant to the Rule 20 motion because constant reference has been that he's interfering with a traffic stop. simply being in the presence of an officer doing his job, or recording an officer doing his job, or, according to Hill, even antagonizing an officer doing his job is not enough to rise to the level where their First Amendment rights and other rights would be violated, up to and including being on a public sidewalk. Those are the crux, and I do think, based on the characterization, we were going to save that for closing, but based on the characterization that he was interfering with a traffic stop, it becomes relevant to the Rule 20 motion as well, so we offer it for that purpose also.
Would you agree with me that it's a little bit different here, where it says making it lawful to interrupt a police officer as opposed to violating a police directive?
I mean, I think but the concern with the Rule 20 motion, Judge, is that he has interrupted a traffic stop.
Well, he interrupted the stop, but then he was given a directive.
Correct, but I believe...
One thing to interrupt, but there's two parts. So you can
Right.
interrupt, but then when you're given a directive, you fail to obey a directive of a law enforcement. I understand what you're saying by interrupting, but I think there's two parts. One, you can interrupt, and two, when you're given a directive to obey the officer's directive, do you think that this still applies?
It has to be a lawful directive, Your Honor, and it's only lawful if he's doing something wrong. Houston v. Hill confirms that he was not.
The behavior in Houston v. Hill is much more egregious as well than anything that we saw in this video Mr. Ruff did or say.
I don't think they were looking at the behavior. I think they were looking at the statute.
But the point being, Your Honor, an officer can't just order you to pat your tummy and rub your head at the same time. The order has to be given for a lawful reason. The issue that Houston v. Hill is raising is that simply engaging with an officer while he's doing his job is not grounds for him to give you a lawful order.
I'm going to agree to disagree with you. That means that in any sort of criminal investigation, no matter how serious, under what you're pitching, individuals could walk on a crime scene, they could walk through a crime scene, they could walk over a crime scene.
Crime scenes are taped off, Judge.
It doesn't matter, right? Because it's directed by the police, stay out of our crime scene. So they go into the crime scene, no charging going into the crime scene, not obeying a lawful order, right?
I mean, at that point, it's potentially criminal trespass back to round one, but...
well, maybe not, though. What if it's a crime scene? What if it's a public area? What if it's the street?
Right, I do think there's a distinction between officers who have cornered off a crime scene. I don't have case law to support that, but that is not. But that is neither what we're dealing with in Hill nor in this case. So I do understand what you're saying, and there could be case law to rebut that.
But there's got to be a point. There's got to be a point where police have to be allowed to do an investigation in a fair and safe manner. There has to be.
Well, and what if that point is when it's taped off? I don't know that it's not.
And back to your point, Your Honor, about the distinction here in regards to the legislative intent, I think is very important. I mean, we have a Title 13 criminal code, and for a very specific reason, maybe that we can't necessarily articulate, they did not choose to put it in that code. They put it in a motor vehicle code. I mean, that in and of itself, I think makes it very abundantly clear that the legislative intent for this was for motor vehicles and the operation of vehicles on a highway or roadway. If not, again, it would be in Title 13, Your Honor, like you stated.
The only thing is just not aware of anything he's telling you all. I don't think there's anything under Title 13.
Judge, the idea that
that would give him the authority to file anything in this case, and that's I don't know that there is.
the idea that lawful orders related to a traffic stop were not contemplated by this statute is absurd. They are in the middle, they are blocking traffic. I mean, I've said it before, we're just rehashing this, but the idea that anybody can come in and interrupt an investigation that's centered around traffic where vehicles are blocking traffic, they are in the act of regulating traffic, literally. And his behavior is interrupting that. He is now implicated in the regulation of traffic by his behavior.
By the state's own
lawful order, they gave a lawful order for him to simply back up. Again, the idea that this isn't implicated or considered by the law it's frankly absurd if you objectively stand back and look at it.
I understand your argument, and that's why I want to look at the statute again. And I think that what I want to do, gentlemen, is I don't want to rule right now. I just want to look at it a little bit closer. I understand what the state's arguing. I understand what you're arguing, counsel. Obviously, as we were doing the trial, my mind, I didn't know what, I never know what the facts are until they start to surface. And so that's what I was thinking of as I looked at the statute. I was thinking, okay, does this apply? But I understand the state's argument because obviously the officers were in their duties. They were conducting their duties, regulating traffic. And so,
if the court wants this briefed, I'm happy to brief it for the court to reach a decision.
And then
I think if you all could assist me in that, that would be great. If you want to, you don't have to. I'm going to leave it up to the parties. I'm going to go read some stuff myself and see what I can find out if there's anything out there regarding this specific statute. I'm going to guess probably not, other than what you've already given me.
And Judge, the applicability of Hill, just so I be clear, because I think we are dealing with a couple of different things. I don't necessarily disagree with the assessment that the statute could apply to an investigation involving a traffic stop. The issue being, we then shift from that. He then has to be interfering with the stop. And essentially what this trial has put on is that he did so by simply walking upon it with his camera. So again, that's where Hill comes into play as well.
Is it interfering with the stop, or is it in the whole context of they're in the process of regulating traffic? I mean, that's what they're doing, right? I mean, I don't think it has to be just in the manner of, at least.
And again, our position would be him simply being present on the scene. It only became an interference when the officer engaged with him. Like, that's when it became an interference. Like, he was walking on a sidewalk and was recording the police. He's allowed to do that.
No, I don't disagree that he's allowed to do that. I don't disagree with that. I can also see, and you know, counsel, my whole history has been criminal defense work my whole life. That's what I've done. And, but I also believe that when police are investigating for their safety, and they're taught this, you don't want someone standing behind you, someone you don't know. When you're doing your investigation, there's reasons why. I can tell you myself personally. I was at a store and there was somebody who was shoplifting, and I don't mean to digress, but I ran out, and I thought there were some issues going on, and I got too close, and I was given a directive immediately. I was just a bystander, but I understand why they wanted me to move away. They said, you're too close, you need to get back. And I was directed to move back, and so obviously I complied because they're doing what they're doing. Now, I wanted to see what was going on, but I think that's just in the normal course of police work. I think you train that way. They don't want me lurking over them. They don't know who I am. They don't know what my intentions are. I think that's just safe police practice.
But at what end does that stop? I mean, at what end can they not just invoke officer safety to command whatever they want?
A lawful order is defined as one that's reasonably related to carrying out the goal. In this case, the officer's goal was to complete a traffic stop. In order to do that, to complete a traffic stop safely, they needed the individual to move. The alternative, Judge, is that any individual on the street can walk up right behind an officer, stand right behind them, and just stay there. The officer has to do this and worry about the person behind them. They can't see both. That is a level of absurdity that the case law does not require officers to operate.
And we would submit that based on the video, he was not right up on him. In fact, at one point, it looked like he was several feet away, and the directive was, every time. And again, this is kind of merged into closing arguments because my understanding is the court's going to take this under advisement as a whole.
I'm just allowing you all to...
I know, and so this is both sides have engaged, and this is very unusual, but we are trying to make our points clear, Judge, that I suppose then, since I know you said you don't need oral argument, I guess we would stand on a Rule 20 motion, and for the record, we believe since a lot of the information merges, we would find that if Rule 20 is met, we still find that the evidence is insufficient to provide proof beyond a reasonable doubt, given that the information provided here, the video shows that he was not right up on the officer, and again, the officer was giving orders for him to stand 30 feet away. He has a right to record what's going on. He can't do that if he's 30 feet away, at least not the audio. I mean, we can't hear what they're saying in here at all. And I mean, we're not on a sidewalk.
Well, hang on, counsel. That's another issue. You believe that they have a right to hear the police investigation, to hear what they're asking them to do?
I believe there's case law that they do have a right to record.
You do have a right to record, but how does that mean if the police are trying to do an interrogation of a suspect that they have a right to
It's 30 feet is a first down.
Right.
It's 10 yards. That's a first down in football. That's not that far.
Your Honor, there's no statute that requires 30 feet. And again, if we're going to
No, I'm
start
not-
having
no,
a subjective...
No, I'm not saying that there is. Counsel.
But
I
at
just-
the end of the day, Judge, that's not the facts of this case.
Right.
The facts of this case are defendant planted his feet right next to the passenger window virtually and said, I'm not moving.
I
That's
disagree
the
with that characterization. Right next to the you can rewatch the video yourself, Your Honor. He was definitely not right next to the passenger's window in any respect. And if we want to take the absurdity on the other end, if we're just going to allow officers to justify everything for officer safety, whether it be a low risk traffic stop or a violent offense, again, this is just a slippery slope to where do our individual rights get superseded by an officer just stating officer safety, and all of a sudden now they can give whatever orders they want, frankly.
No, they can't give any orders they want. They have to have a reasonable orders. And the question then becomes what you all are saying. You can stand wherever you want during any investigation, and that doesn't apply. And there is nothing statutorily. That's why I brought us, even if they take off a crime scene in the middle of the street.
And Judge, I do think there is a distinction between a taped-off crime scene and not. And again, this is not a case where there's a taped-off crime scene, so
Well,
I
tell me
would
what
disagree
crime-
with you there.
Counsel, just tell me what crime under Title 13 you could file. I don't think that you can.
Would it be a trespass? Is it now a restricted area because it's taped off with crime tape? I would submit yes.
I don't know.
I believe at that point a taped-off crime scene is a restricted area that's protected by Statute 13 or Chapter 13.
So in this case, if the officer would have taped off a 30-foot zone,
Sure.
And Your Honor,
I
there's
think he
also
would have had to
obstruction.
comply. But
because it didn't, you think taping it off 30 feet versus telling him to move back 30 feet, there's a difference?
it made a difference in the first case we litigated here today, Judge.
In that case, I was more concerned about whether or not he was on the property itself.
Right, but he didn't cross the tape line. He's aware that he can't do it. So to answer your question, yes, I think it would have made a difference in this case.
So Judge, now we're in a situation where we're saying that a police officer conducting a traffic stop for a simple speeding violation, in order to not have a random individual that he knows nothing about, not their intentions, not their history, not anything, has to put crime scene tape in order to prevent them from standing immediately behind him.
Well, your own officer talked about how dangerous every stop could potentially be. So if we're going to take the position that every stop can be dangerous, then maybe they should. If we're going to say that officer safety is at issue in every stop, then maybe that is the solution. But again, at some point, this is an officer safety issue versus the fact that fundamental rights are being prohibited. And in this particular case, we don't believe the statute applies and have moved for Rule 20. And we don't believe the facts of the case substantially support enough beyond a reasonable doubt that there is a guilty verdict.
And as an aside, Your Honor, obstruction could have been applied as Title 13. Obstruction in a criminal investigation or prosecution. But that requires a higher burden for a reason.
It doesn't.
Or it requires an actual physical act by the defendant, meaning that it recognizes the First Amendment rights in that balance.
That's all we have right now, Judge. Thank you.
Do you have did you give me the exhibit?
No, I don't think I did.
You looked for submissions, I don't have it.
Yeah, no, I got it.
And we didn't
Well,
object.
gentlemen, I didn't have anything else pending, so I appreciate the comments, the arguments. I just don't want to rule from the bench because I want to look at some case law. I want to look at this a little bit closer. And I haven't, in all fairness, I read through Gonzalez, but obviously I haven't had time to read through Hill in its entirety. So,
We appreciate you giving it consideration, Judge. We understand.
all right. So
Just
let's take this under
Sorry, for what
advisement.
it's worth, the state does intend to file to brief the issue.
That would be fine. If, I'm going to leave that up to the parties. If you want to brief the issue, you can.
Do you have a deadline, Judge?
Let me ask what you would need. How much time do you want, Mesa? How's it go? If I say, I don't know, 2 weeks, is that, 10 days?
Yeah, I prefer more rather than less, just because I'm out of town next
Okay,
week.
so how about if I say 2 weeks?
Yeah, that'll work, Judge.
Okay.
No objection.
Yeah, give me something, gentlemen, and we'll go from there, okay?
Yes, Your Honor.
Thank you all. That concludes this matter.
Judge, Mr. Ruff was found guilty on 2 offenses. Do we want to set sentencing out at this time, or do we want to wait kind of hold that in abeyance until we come back on this additional matter and get a ruling.
I guess that's a question for,
State's fine setting it out,
I
Judge.
mean, we'll set it out, or we can, I mean, what do you all?
We can either set, we don't want to go forward today, we can either set it out today or, Judge, wait until there's a court's ruling, and then we could set it either by minute entry if the court's requesting further argument. We could set it at this time. I'll really defer to the court on that. We just don't want to proceed to sentencing today.
All right. Yeah, let me just, how about if we,
Your Honor, we were just speaking with Mr. Hawkins. Since the defendant has 3 other trials coming up in August, we were thinking of pushing sentencing until those are completed as well.
that's fine, let me put something together later on.
Thank you.
That sounds good, Judge. Thank you.
All right, thank you all.
Makes sense.